All right, it's 10:30. I'm going to call the. Whoop. Hey, what's this one? Yeah, I just want to. Somebody's conferring. All right, it's 10:30. I'm going to call the House Judiciary Committee to order, and would you please join me in a Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'm going to first open the hearing on Senate Bill 146 FN, and I will recognize Senator Prentice, the prime sponsor. Of course, absolutely. Yep. Yep. I think we need, yeah, for people, right, exactly. So that, but that's you guys can just scooch over just a little bit. And that, yeah, there you go. Scooch.
That's an underused word, scooch.
Right.
Okay. Yeah, everybody, exactly. All right. Good morning, members of. Good morning, Chair Lynn, members of House Judiciary. It's great to be with you this morning. For the record, my name is Sue Prentice. I'm the State Senator from District 5, covering 15 communities, largely in the Upper Valley, a little bit of Sullivan County, and one beautiful town in Merrimack County, the town of New London. I am here today to introduce Senate Bill 146. And what this bill does is it removes the requirement for the certification of for a cremation. It removes the requirement for a cremation certificate. And I want to make it clear up front before I enter into my opening remarks that this is not the death certificate. Okay, this is a procedural act before, that involves a review of the death certificate, but before a decedent, and that someone who's passed away, can be cremated. Okay, and we have a reason why we're asking for this, which I'll work my way into, and then have Dr. Duvall here to back me, well, to offer, to answer any questions, as well as color, put some color to some of my comments, as a means of, or for the purposes of transparency. Besides being a longtime paramedic, I had the opportunity to work as a deputy medical examiner under Dr. Duvall and her team for probably about 5 years. It was one of the ways I helped pay for my daughter to go to college. So I actually have firsthand experience working with death certificates and working with cremation certificates. So the Office of the Chief Medical Examiner investigates all non-natural deaths, homicides, suicides, accidents, and unexpected natural deaths. That's approximately 2,000 per year. This investigation includes a postmortem exam, which is external, or an autopsy of the body. Most external exams are performed by, right now what we have are 10 full-time ADMEs, or deputy medical examiners. So we used to have a different system. Now we have a system of full-time medical examiners that serve the different regions throughout the state. And these are done at the hospitals as well as they're done at the funeral homes. If it's an autopsy, it comes here to Concord. There is a pathology suite at Concord Hospital where the chief medical examiner or one of the pathologists that works with Dr. Duvall actually performs the autopsy, and that is approximately $600 a year. So I think it's an important point that if it's a non-natural death or if it's an unexpected natural death, okay, that there is a system in place for a deputy medical examiner or the chief medical examiner in law to take, to look at the entire circumstance and in cases as necessary perform an autopsy. So death certificates are expected for all natural deaths and are completed, usually by a primary care provider or an attending physician. And let's remember that primary care providers are not just physicians. They could be a nurse practitioner. They could also be a physician's assistant. There are deaths that occur in a healthcare facility or under a doctor's care, including home hospice. This is the majority. So approximately 12,000 deaths per year are in a healthcare facility. That is the majority under someone's care, and they're the ones that are primarily not authorized, but it's their duty to complete the death certificate. They pick a manner of death as well as a cause of death. So they've been caring for those patients, and this includes home hospice. So when we get up to this point, now we start to move into a family opting for cremation. And that's about 80% of the decedents now are, the family, that decedent has made that choice. The family is moving forward with the funeral home for cremation. So the chief medical examiner, as it is right now in their office, there's no need for further investigation prior to cremation, but there has been in law, and we are one of 4 states that still does this, the requirement for a cremation certificate to be completed. This is about 16,000 cases a year. So the certification process consists of reviewing, and I have gone in and done these. So you go, you get the completed death certificate, you view the body for the sole purpose of detecting any deaths that should have been reported to the office of the chief medical examiner. So a perfect example, as stated here, is that these are typically delayed injuries. So I would go in to a hospital in one of the counties that I was covering and go to do a cremation view, and I would see that it talked about, for a primary cause of death, cardiac arrest in the hospital. So their heart, their heart stopped beating, they stopped breathing. But in reviewing, going down, I would see that there was a fall, okay, or they had been involved in the last few months in some type of car crash, or as an injury prevention professional, I never like to use the word accident, but I'm going to use it here, some kind of accident, which would make me suspicious. Was this some underlying factor that actually made them a traumatic death? So, but what we've found is that that's less than 1%, where our medical examiners, our deputy medical examiners that are out in the field are actually detecting that a case needs that at the point of doing a cremation certificate may need another look. So at that point, they would appropriately act, call the chief medical examiner or who was on call and move in that direction. But this is less than 1%. And again, these are typically delayed injury deaths due to fractures, hip fractures, head injuries, and unfortunately, a lot of them are from folks that are elderly. So it is very delayed and undetected, but we want to make sure that it's appropriate that we capture, what are the causes of someone's death and the factors associated with that. So virtually all of these unreported deaths are identified by reviewing the cause of death on the death certificate, not by inspecting the body. So part of our job, or part of my previous, but there are others that do this now, was to look at the death certificate, start there, and then make sure it all matches. Okay, it's not by reviewing the body itself. So I actually said we're one of 4, we're the 4th state, but there are 3 other states that still require this. And what I would like to offer to the committee in making this choice to change and move away from cremation certification is that we know that, again, it's less than 1% is changing anything, that the majority of people are passing away in the care of a healthcare provider who actually completes that death certificate, that any of the cases that involve unnatural causes like, homicide, suicide, or an accident, they automatically go into the jurisdiction. So it leaves us with, again, this very small population where, again, we have found that less than 1%, that moment of doing a cremation certificate actually changed anything. We have a system now in New Hampshire where we've gone to regional medical examiners versus the system that we had previously. And with the number of cremations and that demand, you have to start looking at where the efficiencies are in the system. This isn't going to change, again, the outcome because the death certificate has already been completed. But what it would do would be allow for more time for the medical examiner, the deputy medical examiners, to be at these different external exams, dealing with the unnatural deaths, some of the unexpected natural deaths. That's somebody that's maybe under the age of 65, who has a sudden cardiac arrest with no medical history. Like, that's an example there. They could focus on those. And so that, I wanted to bring that up as an important point in, if we know that it's not changing anything, it's like that 1%, then we could actually deploy the resources we have to the places that it's needed. And the last, but probably most important thing that I'll say is that the family members and the funeral homes are waiting, they have to wait for a deputy medical examiner to come and do the cremation certificate. And what that, and with the number of cremation certificates that get completed, that can cause a delay, considering that if there is some unfortunate event that is drawing that medical examiner in that region away, they might not be able to get there to later in the day, or even it could get shifted potentially to the next day. So families who had their loved ones are waiting to be cremated so that they can begin, continue with the process of grieving and move them through to being, their life being honored in whichever way that they choose. That is being delayed as well. So with that, I'm going to close my comments. I hope I was able to lay this out logically, and I'm happy to answer any questions. And if I can't, I'm fortunate enough to have my former boss and chief medical examiner, Dr. Duvall, here with me.
Yeah, good morning. My name is Jenny Duval. I'm the chief medical examiner. I've actually been working in the office for almost 24 years now. I just wanted to clarify one thing that Senator Prentice stated. There is value in authorizing cremations. There is value in reviewing the death certificates and making sure that the death was not a death that we should have been notified about. So we don't want to eliminate that. We definitely want to be reviewing these death certificates and taking jurisdiction if there's an injury or some indication on the death certificate that the death should have been reported to us. And that does happen. It's not that often, but 1% of the total number of decedents that are being cremated is what we're talking about. But that's still a large number, because there's 16,000 cremations that we certify every year. The only piece of this legislation that we'd like to change is the requirement to physically view the body prior to issuing that cremation certificate. And there is literature that shows that there is no additional benefit to viewing the body in addition to reviewing the death certificate compared to reviewing the death certificate alone. Because viewing the body doesn't tell you much about how the death happened. It's reviewing that certificate and, if necessary, reviewing medical records. And if I can just give you one example, one of my investigators was reviewing a death certificate and viewing the body prior to cremation. And the death certificate simply said that the decedent had died of pneumonia and had been living in a nursing home. And that's very, very common. But this is a 37-year-old woman who was living in a nursing home. And that triggered an investigation. And the investigation led to reviewing the medical records. And it was determined that this person had been in a nursing home in a persistent vegetative state for 14 years after an attempted strangulation. So this was a homicide at that point, because she passed as a result of complications. And that was not reported to us. And it wouldn't have been discovered but for this investigator reviewing that death certificate and asking questions. It wasn't looking at the body 14 years later. That didn't tell him that she had been a strangulation victim. So we still want to be able to review these death certificates and make sure that this was not a death that should have been reported. We just want to eliminate the view requirement. That requires our investigators, who are spread very thin throughout the state, to be traveling to funeral homes and crematories. And there's a big cost in terms of time and just the work effort in performing this cremation view that is really not adding anything to the process. So that's all we're trying to change here, is just that physical view requirement.
All right, thank you. Questions for either of these witnesses? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I was not aware that death certificates have what I would characterize, based on your testimony, secondary causes of death. So the example, Senator Prentice, that you gave of an elderly person dying and there being underlying fractures, I was not aware that a death certificate would have both causes of death on it. So could you just clarify that?
Sure, I'd be happy to, and Dr. Duvall may have further clarifications, but when you look at a death certificate, it's like A, B, C, like they give you multiple lines because there's a primary cause, but there may be secondary related causes, underlying factors in terms of a medical history that they have, which we'd call like a comorbid condition. So those things are typically listed out on a death certificate. So there's a primary cause, and then if applicable, those secondary, like a medical history that may, be an underlying condition that exacerbated and moved, was a contributory factor, but not the primary reason that they died, that they passed away. Does that clarify for you, Representative Manos? Thank you.
Other Representative Turk.
Yeah, thanks. So I totally understand the logic behind this. I guess my one question is there the low percentage of cases that show up needing this review? I'm wondering whether the possibility of this review happening sort of makes sure that there aren't more of those. If that's making sense, sort of like the way that, tax returns are audited, knowing that you could, so people adhere better. I guess the real question is, maybe it's focused around, cases where maybe there was a malpractice or something involved in terms of, whether or not there would be an incentive not to accurately reflect what happened on the death certificate. And again, I'm not saying this is a reason not to do this. I'm just curious whether or not that logic makes any sense in terms of having the possibility of this review happening as a way to make sure that people uphold the requirement.
So I'm not sure I understand the question, but as I said, there is value in reviewing death certificates. Now, you're right, we have to take at face value whatever the certifier put on there for the cause of death or the contributory causes of death. We review those, and if there are red flags there, we investigate further. But we can't possibly call every certifier for all 16,000, death certificates to make sure that they certified it properly. So, I mean, I think what we're doing has value, and it's manageable without the physical view of the body.
So just so I'm clarifying, the possibility of a physical review would exist if somebody, in looking at the medical record, saw something that would indicate that there's reason to investigate further. It's not taking that off the table.
Correct.
Okay, thank you.
Other questions? Yeah, Representative Tripp and then Representative Manos.
Thank you, Mr. Chair. Thank you for taking my question. This seems to focus on disposal of bodies by cremation. Is there a reason for having that emphasis on this in this bill?
Well, the existing statute, it's been there since the medical examiner's office began, is that death certificates for anyone who will be cremated should be reviewed. And you're right, because it's final. There's no going back to the body if information comes along later. And so that's why it doesn't apply to burials. it only applies to cremations. But 80% of decedents are cremated, so we are going to be reviewing death certificates for the vast majority of people that die in New Hampshire every year.
Yeah.
Representative Manos, did you have or did you have a follow-up, Representative? Tripp? I'm
follow-up,
sorry. Yeah,
please.
no, follow-up. Go ahead.
So in order for the cremation to be done, we have to have a certificate from the medical examiner.
That's correct.
And as you said, the eliminating the requirement to view the body will hasten this process.
Yes,
All right.
just eliminating travel time is,
Yeah, but would we still have the requirement to delay the cremation for at least 2 days?
oh yes, that won't
that
change. Nothing else changed. The only piece we would like to change is the physical view of the body as part of this process.
All right, thank you very much.
Right. Representative Manos, did you have?
Thank you, Mr. Chair, and thank you again for taking my question. I just looked, and this statute was last amended in 2008, which is fairly recently, and so I wanted to know what is the rationale for the view prior to cremation? What is the thought? What is the thought on the benefit of doing that?
Well, I didn't write it, but I surmise that it's to make sure that there's no signs of injury on the body that were not brought to anyone's attention, because cremation is final. But again, it doesn't have to be a medical examiner who's the assistant deputy medical examiner is not the only one who would have viewed that body. So this is a final step before cremation. And so before that, these patients, most of them were in a hospital or a healthcare facility. So medical personnel are viewing that body multiple times a day. There are home deaths as well. A fair number of those are home hospice. So again, there are medical personnel that are there. And if nothing else, if an elderly person lives alone, they're found deceased in their bed, police respond, EMS responds, and then our office is notified. And there's a discussion that goes back and forth between the ADME and law enforcement. If the ADME feels this death is natural and expected, that ADME would be in communication with the attending physician. The attending physician would say, oh yes, this person had end-stage heart failure. This is not unexpected. And the police are saying there's no evidence of any injury on the body, no evidence of foul play on the scene. So there's still a process. There's still a lot of review and investigation that happens no matter what the death is before this final step. It's just trying to eliminate an unnecessary additional view of the body.
Representative Perez.
Thank you, and thank you for taking my question. We have a fiscal note here that says really undetermined, 100,000 to 500. And I hate to mix money with death, but do you see that would be a cost savings to your department? Oh, I got lots of heads nodding over here.
Oh, yes. Sorry.
No, it's okay. So thank you for the question, Representative Perez. This would be a cost savings to the department because the deputy medical examiners would not be out on the road with the attached, mileage and costs that go with that. Their time would be directed to other tasks that were necessary.
Yes, please.
And did you say 80% of they were cremations? Is that what you said? So would this decrease literally be able to cause a decrease in the number of deputy medical examiners? Again, I'm mixing money with death, and I hate to do that.
No, policy, whether it's with those who have passed away or any other issue, it's our responsibility to look at these fiscal notes. So with the number of these that there are, I don't think we can, what we have learned from moving from the system we had to a regional system is that the demand is still high for the physical presence of the deputy medical examiners at homicides, suicides, accidents, unexpected natural deaths. Those still exist. But what's happening is that the number of cremations are on the rise and is requiring families, loved ones to wait when we know that this step of the view, and I'm glad that, Dr. Duvall made that clear that we're talking about the step of the view, is not necessary in determining. And I think based on your background, you maybe have helped fill out a death certificate or time, so you know what that looks like. And again, the overwhelming majority of these folks are in healthcare facilities. So I hope that answers your question. I don't think we can change the system as it is. It is reassigning the duties and being more efficient.
All right, other question? Yes, Representative McFarland.
Thank you, Mr. Chairman. One of the things I haven't heard either of you discuss is the matter of identification. And it seems to me that one of the reasons for the existing language is that while one doesn't wish to envisage such a scenario happening too frequently, it is possible to dig up a buried body. It is much harder to reassemble a cremated one. And so I would just like to understand from you to what extent you feel that there are other controls in place that are effective that would achieve the ability to have assurance as to the identity of the deceased with these changes. And I'd also like to understand a bit more about the motivation in bringing this bill. I've heard all the good reasons why this would save some time and labor and money. But I also heard that you have points of view on both sides of the equation from the Chief Medical Examiner's office. And so I'm just trying to understand where the motivation for the bill came from and how strongly felt that motivation is. Thank you.
Want to split it?
You go first.
Okay. Thank you, Representative McFarland, for your question. So let's talk about identification. The majority of these deaths happen within a healthcare facility, okay? And before they travel from the healthcare facility or even home hospice to a funeral home or a crematorium, and that's where that's where these views are taking place. In part of this process, and I believe that a representative is here to testify today, are funeral directors. So there is the point along the way where they are identified within the healthcare facility. They are turned over, including their identification, which, a driver's license would be one of the most common forms, to go to the funeral directors. And the funeral directors have that check-in point as well as making sure that this is the correct person. So these, there are multiple bites at the apple that these decedents, the folks that passed away, have been properly identified. And it'll be, I think, hearing from the funeral directors would be helpful. But the motivate, so there's number one, and Dr. Duvall can expand on that if she'd like. Number two is the motivation here is knowing that if this system, if the mere view of the body is changing less than 1% of, I don't think outcome is the right, but the pathway, then it's our responsibility to examine this and say, are we doing the best we can for the families? And are we doing the best we can for the system itself, or the people that need external exams, that may need to go to autopsy, the other pressing parts of the pathway. So that, it seemed to be, what I know at this time is that this would serve the families, serve the patients, and would build an efficiency into the system so we can use the personnel that we have to do the other duties that are being waited on. I don't know if that helps clarify. Dr. Duvall?
Yeah, well, I would just add that if there is any question about identification, that's a body that falls under our jurisdiction automatically. So these are decedents who, that they've been identified, they've been seen in a hospital setting or a nursing home setting, or at home with family. I mean, these are not questionable identifications. So the purpose of this cremation certification process is to, again, pick up deaths that should have been reported to us but were not. It's not to confirm the identification. The funeral home is presenting to us a body with an identification with a death certificate. So we're not, running DNA testing to confirm that it is that person. That really falls to the funeral director. And again, if there was ever any question of identification, it would have been a death reported to us up front.
Yes.
So thank you for those answers. And I think that helps inform my next question, which is, if a significant portion of this intent is to help ease the complexity and the burden on these family members, would you be, how would you be disposed toward an amendment that required, in order for this waiving of the viewing by the medical examiner to occur, that requires a next of kin to sign off on that waiver?
Well, I mean, the next of kin has to authorize cremation at the beginning, or cremation does not occur. They're the ones that are choosing and opting for cremation. It's just
Forgive me, but is that true in the case, for example, of somebody where a next of kin cannot be found and the decision is made by the welfare officer or others?
It's in statute, in the funeral director statute, that they are authorized to cremate after a certain period of time if no next of kin can be identified. So that falls under their statute.
And then no next of kin, to your point, Representative McFarland, no next of kin could be identified to actually sign off on that, because they have been, and I have been to funeral homes during my time doing this work, right in the Upper Valley where you live, where they have had, I remember one particular case, they had a decedent that was there for at least 3 months with no next of kin. And what I know about the funeral directors in the state is they're amazing, the work that they do, and they try everything to make sure they button these up correctly, and they honor the wishes of the decedent and the family, and that includes trying to find next of kin, and if they can't, then that's what authorizes it. So there would be nobody there to sign. It's not that they're not open to it, but I don't think it's going to solve. I think that's already covered because they have the authorization to do it, and if no next of kin is locatable, then that was the only time it would trigger that part of the statute, which is the funeral director statute.
Thank you.
Other questions? Other questions for these witnesses? I guess I have just 2 questions, if I could. First, I want to make sure, I may have misunderstood Representative McFarland's question, but it sounded like from one of his earlier questions that he was inquiring as to whether that there might be some opposition to this bill from other people in the medical examiner's office. Did I misunderstand that, or I thought that he might be suggesting that was the case?
Certainly not in the medical examiner's office.
Okay.
What we're trying to do is follow the standard practice around the.
I may just have misunderstood what he was saying, but I thought that there was some suggestion that maybe there was a dispute about whether this bill, a dispute within your office about whether this bill would be a good thing or not.
Well, half my office is here.
Okay.
Not that we're aware of.
Nobody's okay.
Yeah, thank you, Representative.
Okay. The other question I had is with regard to literally the last sentence in the bill, which is on page 2. It says, "The person determining the cause of death shall have viewed the deceased within 24 hours after death," and the bill proposes to strike that. And I'm just, am I understanding that is part of current law, that this requirement of of viewing the deceased within 24 hours. And I'm just curious. I mean, I guess I have two questions. Yes, is that part of current law? And if so, how does that work? And I mean, I would seem that there would be lots of circumstances where you couldn't do that.
Yes, and it is part of current law, and it's also something that we've recognized many years ago that really should be changed. It really doesn't make much sense that the person determining the cause of death has to physically view the body within 24 hours of death, because the cause of death is not on the surface. It's in most cases. You can't tell that someone's has end stage COPD necessarily by just looking at the body, but you can by reading the medical record and knowing the patient, which is where this comes in. These are attending providers that are completing death certificates. They know the patient, they know the medical history. They don't need to go and see the body again to know that that's what caused the death.
Right. I mean, my thought was much simpler than that. I mean, I assume there must be many cases in which the death occurs and there's some delay. I mean, if somebody dies in their home and you don't, a week earlier, and nobody is not discovered for a week, and so there you wouldn't be able to.
Unfortunately, that's true.
That's very true.
Okay.
Yeah.
All right. Any other questions? Seeing none, thank you both very much. Very much appreciated.
Thank you, committee members. Have a great day.
Is there anyone else who wishes to appear on House Bill, I'm sorry, Senate Bill 146? Seeing none, I'm going to close the hearing on Senate Bill 146. And I would now like to open the hearing on Senate Bill 148. And I will recognize Senator Sullivan.
Good morning, Mr. Chairman and members of the committee. I am Victoria Sullivan. I represent Senate District 18, which is Manchester Wards 5 through 9 and the town of Litchfield. And I bring forward this morning Senate Bill 148 FN. This is often referred to as either the Slayer Law or the Son of Sam Law. And we are one of only 2 states in the country without protections for the families of homicide victims. Currently, if someone commits a murder, they can write a book, they can sell a movie right, and they can profit off of their murder. This came to my attention, as you know, I'm from Manchester, and the horrific details around the murder of Harmony Montgomery. It was brought to my attention that her father could potentially profit off of her murder without this law in place. So it is a slightly different version than as was introduced, because we did take the recommendations of the Department of Justice and change it more to their liking. I believe they're here to testify on it as well. And we have one amendment that I asked Representative Alexander to present, and it just makes it effective immediately. So that is the only change that I'm requesting of the committee, and I'm happy to take any questions.
Questions for this witness? You know, I guess I just have a question,
Okay.
and maybe this may be a question that's more appropriate for the next witness, Mr. Agati, but can you just tell me, is this, the text of this bill, is this something that was taken from, you know, sort of other states' legislation?
Yeah, so we painstakingly went through all of the failed attempts of trying to get this passed in New York. I think is the most famous with the Son of Sam. It kept getting shot down by the Supreme Court. This language actually sticks. This language has been tried by the courts, and it sticks.
Great. All right. Any other questions? Seeing none, thank you very much, Senator.
Thank you very much.
Next, I'm going to call on Senior Assistant Attorney General Benjamin Agati.
Thank you very much, Mr. Chairman. Still getting used to seeing you in this particular role as compared to before when seeing you in a robe. And good morning, everybody. Thank you very much for allowing me to speak. My name is Benjamin Agati. Last name is Agati. I'm a Senior Assistant Attorney General here at the New Hampshire Department of Justice. And I've been working there for coming up on 19 years now, working with regards to homicide cases. I think one of the things, and the New Hampshire Department of Justice does not take a position with regards to this particular bill, just to make sure that that is very clear. I think part of what we wanted to address is, first of all, we wanted to go ahead and thank the representative for bringing this forward, because this is an area that does have a gap in it. This is an area that is unaddressed. Unless we've got a fully negotiated plea with somebody, we do not have an ability in our realm to be able to prevent an individual from benefiting off of their particular crimes through, certainly not through the criminal justice system. It's not designed that way. So we do see that this addresses a gap that's there. That being said, with regards to these two different statutes that are set up, I think that there are three things that this committee should definitely think through. One is some of the definitions that are used inside the language that's proposed. The second is the protection that should still be there for ongoing homicide investigations through this proposed operation of the probate court on our RSA 562A. And then the last is the concept of estoppel, to ensure that a probate court finding of a lesser mental state would not somehow affect a possible homicide case from going forward in the future. So for those three things, I think let me just talk about the definitions first. Definitely read, please, we would ask that you would read the statute carefully. Some of them are very, very different. So for example, the term interested person. In this statute of 562A, an interested person would be able to bring forward a particular action in the probate court to prevent another individual from taking part of that person's basically intestate share. Yes, I'm sorry. Apologize. Apologize. I usually operate just by, so if I were to be looking at the very, very first page of this, if we were talking about the concept of the interested person, just for a moment.
I think Representative Tripp had pointed to page 2,
I'm sorry.
line 19.
To line 19, yes. And an interested person, the term of interested person there is undefined. And so the question of who is an interested person, is that a person who is interested because they may have the ability to have an intestate share of that person's estate? Is that a member of the public because they feel that this particular death was something that gathered the public's interest? There's no definition of what an interested person is. One of the other things that makes clear is when we talk about the term, the definition itself of an individual, and I'm looking on line 16 under 562A2, an individual who feloniously and intentionally kills. That phrase, feloniously and intentionally kills, that would incorporate three parts of the homicide statutes that we currently have. The homicide statutes in New Hampshire are capital murder, first-degree murder, second-degree murder, manslaughter, and negligent homicide. These are all of the possible homicide charges that can be brought for the killing of another individual. The language feloniously and intentionally kills means that the mental state that would be used and interpreted by the courts must be one that's either purposeful or knowing. It would not include the lesser mental states of reckless or negligence. That would mean that this statute would apply to an individual who was accused of having committed an act that was capital murder, first-degree murder, or second-degree murder knowing, but not the variation of second-degree to reckless, not manslaughters, not negligent homicides. That is certainly, if that's what the legislature chooses to do, obviously that's the choice. Just to make clear, though, that term intentionally kills will not involve reckless deaths. And that is one variation of the second-degree murders. That is the manslaughters, and those are the negligent homicides because they have lesser mental states. I think one of the best examples I heard about this is if you can think about a charity fundraiser event outside of your local library. They have a little thermometer, and when you fundraise, well, we got $5,000, we got $10,000, we got $15,000. Holy cow, we got $20,000 over the top. That's great. You fill up the thermometer. Intent elements work the same way. Negligent is the lowest level of intent element that we have for intent for killing another. Reckless, you go up the thermometer, knowing, and then purposeful at the very top. this particular statute, the way it's written for saying that somebody intentionally kills, will only involve that top tier, purposeful and knowing deaths. It will not involve second degree murder and others. That's just one example of just some of the terms that are there. And I would say lastly, one of the other terms to look at is if we go to page 2, 3, 4, we're looking on page 4, switching over to the other statute, RSA 507I, subsection, I subsection 4. If we go down to line 32 on that page 4, under Roman numeral 3, the Department of Justice shall have the right to apply for any and all provisional remedies if there is any restitution owed that the Department of Justice seeks to have satisfied. Provisional remedies is not a phrase that we've used here in New Hampshire in any of our statutes before. Without further guidance, the court will probably refer back to a Black's Law Dictionary of what provisional remedies means, which is essentially a temporary action in a civil suit. That's to secure against an irreparable loss. The state of New Hampshire, certainly as this is designed through reporting of the Office of the Victim Witness Assistance, through that, they would not have any cause of action against individuals. So the phrase provisional remedies in there may need further clarification for what the Department of Justice is expected to do in these situations. I think those are just the two areas that I wanted to touch on in the last, and then I'm very happy to take questions, and thank you so much for the additional time today. The last is just with regards to the probate court action and the concept of estoppel. As written currently, the operation of 562A would allow that interested person to bring an act inside of a probate court to be able to prevent a person from unlawfully enriching themselves at the death of the victim. One of the things that is not clear within here is the concept of this probate court operation involving a lesser standard. It's basically, we're down to the level of it being probable cause. We're down to reasonable to believe that the person caused the death. That is a lesser standard than what we would have to prove at trial, where we would have to, of course, prove beyond a reasonable doubt. The issue here that may come up is the idea of estoppel. And so, for example, on estoppel, if the probate court makes a determination through one of these actions that an individual was not responsible for another person's death, and let's say that it was a matter that had not yet been litigated, that we, or maybe it was one of our cold cases that we're finally able to bring forward years down the road, the defendant could argue that the probate court has found that I am not responsible by a very low evidentiary threshold. So now the superior court should be stopped from trying to find me guilty at a higher threshold. By way of an example, there's a homicide case I prosecuted way back at the very beginning where it was just an assault case and the victim ended up dying 2.5 years later after he had been assaulted. He was assaulted by 4 individuals. One of them had gone to trial on the assault charge and was found not guilty. Later on, the state of New Hampshire tried to bring a homicide charge against that person for saying, well, new element of the crime, the victim is now dead. We have a homicide, we should be able to bring it. And the court, rightfully so, said, no, you're stopped from being able to do that. You tried to bring an assault charge. If they're not guilty of the assault, they're not guilty of the murder only because this has changed. The previous action stops the later action. One thing that the statute doesn't address is the concept of whether or not these probate court proceedings would stop the state criminally from being able to prosecute an individual later on. So again, the Department of Justice does not take a position with regards to this bill, but certainly urges the House members to consider those and consider those definitions and decide what tweaks they would like to make going forward, if any.
All right. Questions for this witness? Representative Smith and then Representative Birch.
Thank you very much. First of all, I would like to commend you on the detailed presentation that you gave, making clear, as is always the case, that the Department of Justice is not taking a position on the bill. I would like to ask you, did you testify on this bill in the Senate? Or did someone from DOJ testify?
I did. And you may see AGOTI with regards to what was in the Senate minutes that are there in that particular report, but that's me.
Without having that in front of me, did you make these same points to the Senate?
I did make the only thing of the points that I've made here today that I did not make to the Senate. First of all, I did not use the same analogy of the thermometer to explain mental states. So that was a different example that I used. And second of all, with the idea of that last definition of provisional remedies, I did not address that with the Senate. Quite frankly, we were out of time that particular day. All of my other statements were statements I did make to the Senate.
Thank you very much.
Representative Birch.
Thank you, Mr. Chair, and thank you for the work that you've been doing for the last 19 years. And that comes from a former public defender. So my question really has two parts, but a preliminary question about that I just don't know the answer, and that is the ability of somebody in probate court for discovery. And I'm thinking specifically about discovery, perhaps of an investigator or a prosecutorial file.
That thought and that, I don't want to put words in your mouth, but concern is, I think, very much legitimate. I could certainly envision that a person who was an interested person bringing an action here under 569A would be in probate court, say, now I have to go ahead and be able to prove my case to stop so-and-so from being able to take part of their share. And as a result, I'm going to go ahead and file subpoenas and ask for discovery to be provided by the investigators, or ask for the investigators to come to probate court and testify as to what they know about the crime in order to meet my burden of proof. And with regards to the provisions here, there are no separate provisions that would right now be able to prevent certain details of the investigation from being released. While there certainly could be, and we would, I think for Department of Justice, we would certainly ask the probate court to put protective orders on any information that is shared. But with that, especially if the person that they're trying to stop from taking a share is the suspect in the case, the suspect would certainly, even under a protective order, be able to have access to that same information that was provided and subpoenaed.
Thank you. And if I may follow
Yes.
up.
Yep.
And kind of the corollary question is the person who's subject to the investigation by the AG's office or whatever is brought into the probate court. I assume that if the matter is still potentially chargeable by the AG's office, that the person brought in might be well advised to exercise his or her Fifth Amendment rights and would render this hearing potentially one-sided. Is that a concern, looking over towards the interests of the putative defendant, of concern to somebody interested in the administration of justice?
I think that is certainly a situation where that person may be well advised. Let's assume that they have somebody who's helping them in the probate court, and maybe they have separate counsel who's helping them with any potential criminal matters. If I were the defense attorney in that case, I would very well advise them that whatever you say here could be used certainly against you later on. This isn't a recorded hearing. You're likely going to be under oath if you need to provide a statement, and those words could be used against you. So yes, certainly I could see that they would be, I wouldn't say in a bind, but I certainly say that there's some very hard choices to have to make at that point. Also, with regards to the matter going forward, I don't believe that the records of those hearings necessarily, while they would be all within the probate court, that certainly would not necessarily be a sealed matter that would be presented. And so I could envision, let's say if I were sitting on the other side of the aisle at this moment, to say to myself, okay, if that happens, I wouldn't be surprised if there's an investigator back in the room waiting to see who says what.
Thank you.
Other questions? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. I wanted to bring your attention to page 3, lines 2, 3, and 4, and the situation where no proceedings have been commenced or filed with the probate court, and yet assets relating to the decedent's estate can be turned over to the probate court, as I read this. And I was uncertain about that, how the probate court can manage assets or accept assets from the decedent's estate when there's no case filed, and what obligation would that be on the probate court to manage those assets for the benefit of the heirs?
That is something certainly that I had addressed with regards to my previous testimony in front of the Senate hearing, is that this is something that you're then asking the probate court to take on. And those are protections of assets that may include any asset as defined here.
Right.
So not only are we talking about proper financial management of finance assets and others, you could also be talking about real property. You could be talking about a person's home. You could be talking about cars, furniture, anything else that has possible great value for assets. I know that with regards to the homicide unit, we are probably one of the biggest offenders of taking up evidence room space at courthouses. Our trials tend to take up a lot of space. Sometimes we have literally bought in walls and sections of ceiling that the court then has to store. And that storage has to be for hearings, for trials, for until the appellate, the direct appeal is over with. That's a significant period of time. With that, the probate court, through this, could be asked to store much larger items than certainly we even ask for. Again, you're right. That is a consideration the probate court would have to take into account. I don't know how they would operate. I'm not familiar enough with probate court activity to be able to answer how they will handle that. I'm sorry.
Other questions for this witness? Representative Birch.
Thank you. I just wanted to quickly follow up, and there's no negative inference in the following question. You made reference to an investigator might be there, might pick up some information. Can you envision a scenario where there's a prosecutor in your office that is unable to bring a case and is speaking to a relative of a victim and say, we're kind of stymied, but you can go into probate court and maybe we can get some good information out of, the putative defendant and the like. Can you see at least the possibility that might happen?
I guess I could see the possibility, but the problem with that is that in the long term, I don't feel that that's necessarily going to be helpful to the investigation. The primary concern I could see of the investigators and prosecutors here would be upon detailed information being released and that person then being able to take steps to usually falsify evidence or tamper with other witnesses. So could I see that? Is it a possibility? Yes. I just think the chances of it are probably the same as me winning Mega Millions. I'd have to buy a ticket first, but I think that the chances are slim. But are they there? Yes, I think we would be foolish to say that they don't possibly exist.
Other questions for this witness? So, I wonder if I could ask you, Mr. Gotti, and I understand that the Attorney General's office is not taking a position on the bill.
Yes, sir.
But you've raised some very valuable, it seems to me, points about various things in terms of language and stuff like that. And I wonder if the Attorney General's office would be willing, without taking a position on the bill, to, provide us some suggested language for things that you think are, areas of concern that ought to be, because I mean, obviously you and your office are the experts in this area. If there are things that, you see language that's problematic, I think we would find it very helpful if you could, sort of mark up the bill and say, okay, look, here's a problem, and this is one way to solve the problem.
I think we would,
I'm sorry, Representative Smith.
I have a question. Hasn't the witness already done that for us? We as the legislative branch having the responsibility to deal. He has by line, by section, identified exactly what the problems are and why. Is it, do you really want to ask the third branch to write a new bill for us?
Well, I guess I guess what I would say is I think so. Again, obviously only if they're willing to do it. I'm not suggesting, in any way to try to coerce you into doing it. But what I am saying is it seems to me that he has given us sort of specific points, but he hasn't really given us, exactly. For example, he talked about provisional remedies. Now, you may have some, it may be that you would say that you would think after you've had a chance to think about it a little bit more, well, you ought to change that language to say something else. Now, if Representative, I agree with you, Representative Smith, could we do that? Yes, I think we could. All I'm saying is the Attorney General's office probably has much more experience than any of us. And to the extent that they could offer us specific language, I think it would be a benefit for us to have that. We might in the end not agree with it, but it would be.
If I could just follow up and then I'll let this go. I don't want anybody to ever think that I am in the business of trying to protect the Department of Justice. I am not in that business. I'm one of the old school that believes the Attorney General's here to represent not state agencies, but the people of the state. But I know that's old-fashioned. My point is that this is a legislative problem. I believe that the witness came to us clearly seeing the need to identify major problem areas. And I just think it's the legislature's responsibility to decide whether this bill is ready for prime time, and I won't belabor the situation. Thank you.
All right, no, thank you. And I guess, again, I want to emphasize, Mr. Agati, if you're uncomfortable about this at all, or you talk to Mr. Formella and he's uncomfortable, I'm not in any way suggesting you should do this, but I don't see, and I direct this really partially to Representative Smith, I don't see this as any different. For example, we are going to have a bill that we're going to hear this afternoon, 263, in which I know that several lobbyists who have interest in this have suggested language. And we may or may not think that that language is appropriate, but it's certainly at least helpful, something that we should think about. And I don't really see that that's any different than what we're asking Mr. Agati to do here if the Attorney General's office is willing. I mean, I guess what I would say is I would rather have a situation in which an office with expertise in this area gives us a sort of an informed view of what they think the issues are, rather than us using our best effort to try to come up with something, but doing not as good a job.
Mr. Chair?
Yes.
Mr. Chair, I hope you recognize that some people on this committee do have a certain level of expertise in this area and may actually have amendments in mind.
I absolutely agree with that. I mean, I think with due respect, I'm sure you have some expertise, and I have. This is not an area that is completely unfamiliar to me either. But nonetheless, I think that the Attorney General's office still brings a great deal to the table. Representative Alexander.
Thank you, Mr. Chair. I agree with my friend from Westmoreland. Perhaps this might be a great bill to send to a small subcommittee that maybe the AG's office would be inclined to attend.
That sounds like an excellent idea to me.
And then we can have a smaller working group on this.
Sounds like an excellent idea to me. All right. Any other questions? Seeing none, Mr. Agati, thank you very much. Appreciate your being here.
All right. Thank you very much for your time, ladies and gentlemen.
Just take out that section.
I'm sorry, ma'am, I couldn't hear that. I'm in your employee, so just let me know.
So let's have the two of us be on the committee.
Who wishes to be heard on SB 148? I should say, anybody else who wishes to be heard on SB 148? Seeing none, I'm going to close the hearing on SB 148.
Put the two of us on.
Before we recess, let me ask, my sense is, but I'm not going to do this if anybody objects. My sense is that SB 146 that we heard earlier might be something that it would be appropriate to exec. But if anybody has any concerns about that, then I won't do that. Everybody all right with execing 146? Okay. Hang on.
Mr. Chair, in the meantime, would you give your blessing to us creating a small subcommittee
Yeah,
on
of course.
SB 148?
Absolutely.
Myself and Representative Birch would like to do that, but if anybody else, Representative Manos?
Representative Manos, okay, sure. No, that's fine. All right. So, and Representative Alexander, under the theory that the volunteer always gets to be in charge, I will make you the chair of the subcommittee.
I'm happy to do that.
All right.
Perfect. Just the three of us? Anybody else?
I'd say that you three. And again, I encourage you to speak to Mr. Regati. I think he would probably have very useful suggestions.
Thank you.
Also have a Senate testimony, which
I
is
don't-
quite extensive.
Okay, great. All right. So I guess what I wanted to say is I've closed the hearing on 148. I would propose to exec 146, but I will not do that if anybody has any objection to that. But it just seemed like, it seems, candidly to me, it seemed like kind of a no-brainer to do what is proposed here. But does anybody have any objection to execing 146? Yeah, the chair recognizes Representative Smith.
Thank you, Mr. Chair. As to Senate Bill 146, I move ought to pass.
All right, is there a second? Seconded by Representative Manos. All right. Representative Smith, do you wish to speak to the motion? If you
Well,
think
I'll speak very quickly to the motion of ought to pass. I think first of all, I just do want to make a very quick comment that it's unusual that we have as the prime sponsor someone who is not only a legislator, in this case a senator, but someone who, in terms of a professional life outside of the legislature, is particularly knowledgeable on the subject. And that, I think, helps to add some credence to this bill. There seemed to me to be very strong argument to support this bill in that in a time of when we don't have enough staff and we certainly don't have enough money to pay mileage, the more efficiently we can use the medical examiner and her deputies, and the sooner, without in any way denying the accuracy and the necessary detail, that by following this proposed legislation, we're able to, I think, better meet everybody's needs. The state's needs, the funeral home's needs, and the family's needs.
anyone else wish to be heard on SB 146? Yes, Representative Perez.
I just have one concern. For a period of time, I worked in the mountains of the Rocky Mountains in a little 15-bed hospital, and we had a lot of travel nurses, and we had an accident that involved, we had a lot of and illegals, but that doesn't really make a difference in that area. We did lots of babies delivered there. But anyway, we had a horrible automobile accident, and there were 3 people there that were in the hospital. 2 were able to leave the hospital and leave the country, and 1 was there for a long period of time. And then we had another person come in who was in a coma. Now, this is extreme, but this happened. And the person who was in the original automobile accident had been there for a long time, had multiple nurses. We had lots of travel nurses. This gentleman died, and he was tagged wrong. His toe was tagged wrong, and that happens. He tagged wrong. Nobody was around. Nobody knew who he was, nothing. He was tagged wrong. He was taken to the funeral home. He was there for a long period of time. I think it was a minimum of 2 weeks, and he was cremated. Wrong name. We say if one person goes to the death penalty who is wrongly convicted, that's one person too many. That's my only concern about this, is eyes on people makes a difference. So.
Yes, Representative McFarland.
Thank you, Mr. Chairman. I want to echo Representative Perez's concerns. And I also felt that when I asked the question around whether or not there would be amenability by the sponsors to an amendment that would limit this to only cases where a next of kin, a family member, had in fact viewed the body and said, yes, I want to do cremation, I want to waive this requirement. The responses were interesting because what I hear is an overt assumption that the medical institutions and the medical practitioners are infallible in regards to identification. And I think Christine set out very well why that's not so.
Okay, you know, I guess the thing that I'm not, I mean, I don't dispute that identification is obviously very, very important, but the thing I'm not clear on is, as I understood the process that was described, it's not clear to me how the medical examiner would, I mean, the medical examiner presumably doesn't know, you know, doesn't know whether the person is Mr. X or Mr. Y. So how does that help?
I'm not saying that's apples to apples, but I'm just saying those type of mistakes happen. And one more set of eyes. I really liked the idea about having a family member. That wouldn't have helped in this case. This was a horrible, outrageous thing. I actually was off for a week. Otherwise, I would have been able to stop it because I knew who that person was. But I didn't know that they were tagged wrong until it was too late. When I was a student nurse, we had patients that were tagged wrong when I was in Boston. So I just think another set of eyes on this, another verification on this, is just something that we need to do. I could see, and as far as the fiscal note, I don't understand why, if you're going to eliminate this process and it happens 80% of people are, why that wouldn't lower the number of people that needed to work too. That's on another whole sidebar. But I just think another set of eyes makes a difference when we're talking about a person's life.
Could I ask Representative Perez a question?
Sure, yeah.
Thank you. How many sets of eyes would you consider appropriate? 1, 2, 5, 10?
Well, we're not talking 1, 2, I-10. We're talking about the fact that a patient has died. They were pronounced by the doctor, okay, signed by the doctor. The nurse calls, signed by the doctor. I'm saying in a hospital setting. They then have the funeral parlor come, okay. Now that funeral parlor person doesn't know who that person is. They're taking the word of who it was. I think a family member would be a huge thing for that. I just am concerned about so much goes on. We hear about so many people, things happening to them in nursing homes, in hospitals and stuff. I just think this is just one more step to make sure that there are no literature marks around their throat when somebody's looking at them.
But I guess I want to deal with Representative McFarland's question point secondly. But the thing mean, I guess the thing that if you seem to be making, I think, Representative Perez, two different points. If the question is one of identity, then the problem that I have is I don't think that there's, at least as was described here and as is stated in the statute, I don't think that there's anything that says that the medical examiner
I agree.
has to be able to identify the person. In other
No,
words,
I understand that.
and in terms of the, you know, the saw the ligature, that kind of thing. I mean, I guess I do agree with that. I suppose that it is, you know, marginally, marginally, I suppose there could be a case where somebody else in the, you know, in the sort of determining that somebody's died and the cause of death and all that has screwed up, would probably have to be a pretty blatant screw up, but I would agree that
happened.
probably could have happened. And then if the medical examiner comes and looks at the body, would see the ligature or
Right.
whatever and say, wait a minute, how could you have possibly said this was you know, the person died of cancer or something?
Let me put it this way. Let's go along with the philosophy that if it ain't broke, you don't have to. This has been working. This works. What is the motive for changing something that has been done and it works very well? What is the motive for that? Obviously, it's not a financial motive. They're not going to cut the number of people or add people to it. So why are we doing this if this has gone along to protect the people that have died? So I'm one of what, 18 of us. So
but you know, I just want to sort of follow through, and then I want to recognize Representative Tripp. But I think your point about the financial implications of this, I mean, I tend to agree with you on this, and I would, you know, my inclination would be maybe it's too late this year, but you know, it's certainly at some point in the future. I would think that somebody, probably the finance committee, would be wanting to ask some very tough questions to the medical examiner's office of, wait a minute, we're saving $500,000 or whatever it is by eliminating this travel. How come why can't we cut your budget by, you know, something? I mean, I think that's a very good point. But I'm not convinced, I guess I would say, on the issue of the identity. But Representative Tripp.
To say I don't know anything about death certificates is being generous. Is there a photo of the deceased attached to the death certificate?
I don't think so.
Well, you know, that sounds like a great idea for a bill next year. You know, thank you.
You know, and Representative McFarland, on your point, I guess if I understood the testimony, it was that somebody, if there's a family member, it's the family member that would be authorizing the cremation. And so in the circumstances where there isn't such a person to do that, it's because they're, you know, I'm not quite sure how we would, I mean, what that would mean that you could never do this when there was not a family member.
Right. Yeah. And I think, Mr. Chairman, I agree with you in your earlier statement that the language that they seek to change does not instruct the medical examiner to establish identity. And I think we heard in the testimony some allusions, not direct assertions, but some allusions to the fact that the funeral director has other statutory responsibilities, including, it sounds like, related to identity and related to determining next of kin. So I'm not saying that there aren't other controls in statute around this. But I certainly, I share Representative Tripp's point of view that I do not feel like I have a good handle on these statutes, and I was trying to look some of them up during the hearing. That said, my understanding is in New Hampshire you're not required to use a funeral director, you are allowed, and I think rightly so, to bury a body on your own land, for example, if you meet certain criteria. And I think that the concern I have is not that this is a bad bill in the main. For the most part, I suspect this is one that we can and should pass. But I think when we talk about what are the edge cases, what are the few circumstances in which it might be subject to not even necessarily abuse, maybe just something falling through the cracks. What I heard from the testimony was not a desire to contemplate those edge cases and contemplate how we can attend to those edge cases. And so to your point, where you're saying, would that mean if there's no next of kin determinable that this couldn't apply? Well, I mean, that's what I would hope. You know, if we're saying it will save $100,000 to $500,000 of travel costs, and that almost all of those circumstances are circumstances where the next of kin is known, where the family is wanting this cremation to happen swiftly so that they can move on, then we would still be saving the vast majority of those $100,000 to $500,000, even if we did have such an exemption in there requiring the viewing for folks where no next of kin is identifiable.
Okay. All right. No, that's a valid point. So I guess the question I have is this. We have at least two members who have raised some concerns. I guess what I'm just speaking for myself, I would be prepared to vote on this now, but in light of the concerns that have been raised, if anybody else other than these two would prefer not to, wants to sort of think about this longer before we vote, then if anybody wants to do that, I'm more than willing to do that.
And the motion has been seconded. There's been debate. You would have to ask the maker of the motion and the seconder to withdraw the motion. Or the other way to do it is to go ahead with the vote. And if in fact the motion doesn't pass, then you're open to other actions.
Okay. All right. So I heard what's being said. I guess what I would say is I'm going to take a straw vote on the issue of what?
You've already had a motion on the floor, Mr. Chairman.
Well,
I'm not trying to stop the vote. I just would express my concern. So
Same.
I have no problem.
Mr. Chair, as another chair, I believe you can recess an executive session at any time, but I do think that you should just call the vote.
all right. So all right. So I'm just, is anybody uncomfortable with my proceeding to the vote?
There's no choice.
Okay, all right. So, well, there would be a choice to recess, I suppose. All right. So, seeing none, then I would ask the motion ought to pass. Moved by Representative Smith, second by Representative Manos. I don't see anybody desiring further discussion, so I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Alexander,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
No.
Representative Kutab,
No.
Representative Perez,
No.
clerk votes no. Representative McFarland,
No.
Representative Smith, Representative Horrigan,
No.
Representative Birch,
Yes.
Representative Page,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
and Chairman Lynn.
Yes.
10 yeas, 6 nays.
All right.
Did I miss?
10-6.
Okay.
All right. Representative Smith, may I ask you to write the majority report? Will there be a minority report? Seeing none? Okay, no minority. No minority. All right. Let's go to lunch. I think Yeah, we're going to form a subcommittee and we got some work to do on that. All right.
Just going to regular calendar.
Yes, this will go on the regular calendar. Yes. All right. Regular. All right. Let's get some lunch. I'm closing the executive session on 146. All right. All right, it's 1:30. I'm going to call the House Judiciary Committee back to order. And I'm going to open the hearing on Senate Bill 189. And I'd like to recognize Tommy O'Neill on behalf of Senator Prentice, the prime sponsor of the bill. Mr. O'Neill.
Thank you, and good afternoon, Mr. Chairman and members of House Judiciary. For the record, my name is Tommy O'Neill, and I am the Minority Caucus Director, here to introduce SB 189 on behalf of Senator Sue Prentice, the Senator from District 5. SB 189 is a request of the New Hampshire Secretary of State's Office, Division of Vital Records. This bill would move the filing of fetal death records from paper to electronic submission, therefore bringing efficiency, being timely for the families, modernizing and improving the existing process for the filing of fetal death reports. All death records in New Hampshire are filed electronically except for fetal deaths, and this would align all practices. Ms. Kristen Martino, who I believe is here from the Division of Vital Records, can provide details on this proposed conversion and our current reporting practices. Thank you.
Okay. Any questions for this witness? Seeing none? I'm sorry, Representative Alexander.
Thank you, Mr. Chair, and thank you for taking my question. My question is regarding page 1, line 3, for every fetal death as defined in RSA 5C:1. That has to do with unintentional deaths after 20 weeks of gestation. Does that include abortions?
I do not know. I do not.
Okay, I'd like the senator's opinion on whether we should
Okay,
include
I believe
abortion
she
statistics
is
in this bill.
Introducing another bill right now. I believe she will be here shortly after that too.
That'd be great.
Answer any questions.
Thank you.
All right, of course.
Other questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Kristen Martino, please.
Good afternoon. Thank you, Chair. I'm Kristen Martino. I'm the Director of Vital Records for the state of New Hampshire. I work under the Secretary of State's office. To answer the question that was just brought up, it does not collect those statistics. It is only for stillbirths. So the purpose of the bill is to modernize and improve our existing process for filing fetal death reports. And the best way to explain what a fetal death is with a term that most people are familiar with, which is a stillbirth. A fetal death is a stillbirth that happens to meet certain parameters within our statutes as being reportable, which is by weight or weeks. All states collect and report fetal death data to the Center for Disease Control, which is the CDC. Most states, including New Hampshire, report fetal deaths gestation of 20 weeks or more, or 350 grams in weight. Under RSA 5C5, New Hampshire follows what is known as the national standard for all birth, death, and fetal death records. One purpose of the national standard is to provide a uniformity in information that is being collected and analyzed to ensure consistency in data for health statistics. Enclosed in your packets, I've provided a copy of the national standard as well as New Hampshire's existing fetal death report. They're at the very back here for you. This is also a side-by-side of the proposed changes to the statutes next to the existing. You will notice that New Hampshire very closely follows the national standard, with the only really big difference being with the disposition of the fetal remains. You'll notice that we flesh that area out a little bit more in our form. As to the filing process, currently when a fetal death occurs, the birth attendant manually by pen to paper completes the fetal death report form. The completed form is mailed to the Division of Vital Records, where it's reviewed by our death coordinator for completeness. Most of the time, the fetal death forms are incomplete, requiring our death coordinator to contact the hospital for further information, sometimes multiple times for the same record. Once the required information is obtained, the death coordinator files the record into our electronic vital records registry system, which we refer to as Nevern Plus. So if you hear me talk about Nevern, that's our database that we're using for vital records. One of the main purposes of the bill is to allow for a One of the main purposes of the bill is to allow for a hospital or institution which regularly electronically files birth certificates to also file fetal deaths into Nevern Plus. Hospitals and institutions without maternity wards will continue to file the paper fetal death report form with the Division of Vital Records using our current method. There is thankfully a very low volume of fetal deaths occurring within New Hampshire. In 2023, we had 44, and in 2024, there were 32. Of the 32 fetal deaths in 2024, 31 of them occurred in a hospital with an active maternity ward. Although most fetal deaths occur in hospitals with active maternity wards, we anticipate this process will have a low impact on those facilities overall, just because there is such a low volume. New Hampshire currently has 15 hospitals with active maternity wards and 3 birthing centers, all of which report births electronically. Each hospital with the maternity ward and the birthing centers have at least one birth registrar on staff to enter the birth records into Nevern Plus. Birth registrars' roles will be expanded within our system to allow them to enter fetal death records. So we are also developing a fetal death registrar role. So if a hospital would like to designate someone other than their birth registrars to enter the records, they can do that. The benefit of allowing the hospitals to enter the records will provide a far more efficient method and will result in more timely filings. It'll eliminate the back and forth queries between the DVRA death coordinator and the hospitals. Another benefit of filing electronically is the ability for a burial in transit permit to be issued from the Nevern Plus database. So if you look at the New Hampshire form that I've given all of you, the fetal death, you'll see at the very bottom, there is a burial transit form. Those are currently being filled out pen to paper as well. So this will be a much more streamlined process for our funeral directors. This will only apply to fetal deaths that are being filed electronically by the hospital or birthing center. Pen to paper will still be required in some instances, but not many. For example, if this process was in place for 2024, 31 of the burial transit permits would have been issued via Nevern Plus, and only 1 would have had to have been pen to paper. We anticipate a low impact on our New Hampshire licensed funeral directors, as unlike a standard death certificate, they will only be responsible for entering disposition information. This is also seen as a potential benefit to the funeral directors, as it is often difficult for them to obtain all the information needed for the pen to paper method while at the hospital. Often they have been contacted to pick up the remains, but they have not officially met with the family to obtain necessary information. This allows them to obtain information later so that they can carry out their duties efficiently without having to immediately disturb a grieving family. And so finally, there is no fiscal impact with this bill. We recently had to go through a rewrite of our system to move it out of one platform onto another. And we've already built this into place. All we really have to do is turn it on if this law were to pass. And thank you for listening to my testimony. And if you have any questions, I'd be happy to answer them.
Questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman. I will confess before I ask my question that you were talking very quickly. It almost sounded as if you were reading off of a piece of paper. Perhaps if you were, you could provide a copy of that to the committee.
I can do that.
My question is this. If I look at the sample paperwork that you provided to us, there's, I think, a good summary of what I presume you're trying to achieve here in the bottom right on the top, bottom left on the top page there, where it says, and I'm paraphrasing, the proposed language will allow for direct electronic filing of fetal deaths at the hospital level versus at the Division of Vital Records. So if I'm understanding this correctly, your hope is that we will have electronic filing, your hope is, or more electronic filing, and your hope is that electronic filing will occur via the hospitals.
Correct.
And I would therefore ask the question, how does this take care of the circumstances where parents wish to exercise their rights to privacy, where they do not wish to have electronic records on their fetus, and they do not wish to have those electronic records handled by the hospitals? We have a history in this state of having hospitals that disregard patients' instructions with regard to electronic records. And I'm curious as to why we would be advocating for more of the same.
So I'm not sure exactly how to answer that, but I'm going to do my best for you. Currently, with births that are occurring in hospital, all of that is handled electronically as well. They already have that in place. When you have a child, a birth worksheet is filled out. That information is keyed electronically into our database, which is known as Nevern Plus. That allows all that information to be entered directly by the hospital, creates the birth certificate, creates all the health statistic information that is then transferred to the New Hampshire Department of Health and Human Services, as well as to the CDC. This is basically following the same line. So right now we are already filing electronically. It's just being mailed to us to do. It's a paper form that is now being handled by my staff and entered into the same database. So all this would do is allow that same person who's doing the birth worksheet the same ability to enter that in rather than my staff entering it in.
Other questions? Yes, Representative Peterno.
Thank you, Mr. Chairman, and thank you for taking my question. Sorry, back and forth between reading glasses and looking at you. I'm looking at the actual bill on line 21, and you're repealing RSA 5C:75 and reenacting it. And I'm confused, just a little confused, because most of this is referring to a fetus, but when we get to line 21, it says if the parents do not choose to provide a name, the first name shall be listed as baby girl, baby boy, or baby unknown. So are we talking about a baby or are we talking about a fetus?
So all I was doing with this particular statute was taking existing language and just simply trying to clarify it. That is language that has already been existing. It's nothing that I'm proposing to add or change. It's something that's already been there.
In the current statute?
It is in the current statute, yes.
Other question, Representative Alexander.
Not in the one you're...
Thank you, Mr. Chair. Thank you for taking my question. I'm looking at, hold on, I'm going to wave off for a minute.
Okay, sure. Other questions? Yes. Representative, please go ahead.
Thank you, Mr. Chair. I guess the fact that my wife does electronic medical records for a hospital, I was just curious how much that situation can be, a program created, because that's what she does. She writes programs and do all that. So some of this would just automatically happen.
So we already have software in place that exists. That's our Nevern database. So it's already written, it's already there because we're utilizing it already at the state level. We would just be having the hospital access it the same way they would to enter a birth record.
Okay.
I hope that answers. I'm sorry.
Right.
Do you know if there's
yes.
electronic? Okay. No.
Go ahead.
Do you know if there's electronic medical record software that these organize, or is that hospital by hospital that you'd have to have?
My assumption is it's hospital by hospital. We only deal with our software system here.
Okay.
Representative Alexander.
Thank you, and I appreciate you being patient with me. Can you talk about the infrastructure that software has to collect data? I guess I'm wondering, because you said there were only 44 unintentional stillbirths last year. Can you talk to me about why we collect this data and what it's used for?
So the data is collected and given both to the New Hampshire Department of Health and Human Services, who would be better off answering exactly what they do with that data. And then the CDC also collects it. But that information goes into studying maternal health and health statistics surrounding fetal deaths. So it's things that they use to study, like, why did this miscarriage or this stillbirth or whatever it is happen. So that's what they're doing with it. It's being published nationally. It's de-identified. It's not anyone's personal information being given to them, but they use it to help increase healthcare.
Thank you. And just follow up.
Yes.
Do you anticipate that your existing software can handle data regarding the intentional killing of babies after 20 weeks?
It would have to be something that we would rewrite, and this came up not long ago when I was looking at some other bills. It would probably be about $1 million to implement.
Okay, thank you.
It's expensive software, unfortunately.
Other questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you for taking my question. The form that you gave us, does this reflect the statute, the existing statute? Is there any information on the form that is not in statute? And I'd like to know whether this reflects the statute.
Right. So I'm giving you two forms just to kind of help illustrate this for you. So you have the U.S. National Standard, which is what we follow, and RSA 5C, I believe it's 5, instructs us that we follow the national standard, which we have been doing. And New Hampshire's form, which you are also holding up, that is modeled after that form. So currently within 5C75, some of that information that we were collecting as part of the national standard under RSA 5C5 was not in 5C75, so I'm seeking to add that to clarify that this is what we are doing. I'm trying to bring it into compliance with 5C5.
Okay, thank you.
Representative Horgan.
Yes, you mentioned there's a very small number of babies of fetal deaths, and there is a definition in the RSA of fetal death, and it's also there's also, like, I see a listing on the form. I don't know if this data exists, but how many births do you have where the baby lives a very brief time after being born and then dies immediately after birth? I mean,
That I don't have a stat for you
Yeah.
on that today. I'm sorry.
follow-up. You do have a thing
Sure.
here for the baby dies during labor, though. That is one of the check boxes here. So do you know if those are usually reported as births or not on the current procedure?
So if a baby is delivered alive and then subsequently dies, it's considered a birth record and then a separate subsequent death record. If the child is, or if the fetus is delivered not alive, then this would be considered a stillbirth. So there's different signs, and again, I'm not a medical professional, so I can't tell you exactly what those signs are that they're looking for. But if there's not signs of life upon that delivery, it's considered a fetal death. And I'm not prepared to answer stats on the nitty gritty of how many we do and how many we don't, where that instance comes into play.
I understand the technicalities I've been involved with myself, as you know. Thanks.
Representative McFarland.
Thank you, Mr. Chairman. Regarding the New Hampshire Vital Records Information Network Plus database to which you allude, who presently has access to that database, and to what extent will this change that's contemplated by this bill enlarge the user population on that database? And to what extent has that interface been subject to penetration testing, and have the reports of that been made public?
As far as the IT side goes, I'm not prepared to answer that for you, but I can absolutely pull that information together and submit it to the chair. My IT staff can handle that. Right now, I believe we have about 3,000 users statewide. And so let me just explain. So this is every vital record event that happens in the state of New Hampshire. We're talking birth, death, marriage, fetal death, divorce, dissolution. So we have your town and city clerks have access to it so they can issue certified copies. Your hospitals have access so that they can input data. Funeral directors enter death. But everybody is defined very specifically by a user role. So a town clerk only has access to do certain functions and cannot see anything else that's happening within that system. There's only 5 of us in the state that have what's considered an admin level where we could go in and see that if we had to. But it's all very limited by user role. And we're looking to hopefully use the same people who are already keying on birth records, since it's usually happening in those facilities, in those areas of the facility. They already have access.
So, follow up, go ahead.
So thank you for the answer, which I think covered most of my points, although I'm not still 100% clear as to whether this would mean a material increase in the particular role that has the capability to register a birth and a fetal death. Or one or the other or both. So if you can clarify, that'd be helpful. But I guess the other question that I have with that is, to what extent do we have controls to detect abuses of that, and to what extent do the threat models change, given that you now have staff in the hospitals that are able to create records of identities in this way?
So again, we're looking to use similar roles that are already in existence, so we wouldn't be opening it up necessarily to anybody new per se, although they could have somebody that they want to do that just does these records. Can you restate that question for me, please? I just want to make sure.
Yeah, I guess what I'm asking is, if I understand correctly, and I'm going to go back and review it more closely, but
Sure.
If you have somebody in the hospital who's now able electronically, without it going through an individual scrutinizing it at the state level, to insert this record, what new abuse cases does that introduce, and what controls do you have that would control for that?
So we have data quality in place. We have people who check our data quality to ensure that records are being filed correctly. And then if there was any type of an issue there, they would follow up with the user. Again, my IT department can get more specific as to how they go through and they verify and make sure that there's nobody in there that shouldn't be in there. We are very...
Yeah, I was just talking purely about the business controls.
Again, I'll have to have my IT staff get that information for you. They're much better equipped to answer that.
Other questions? So I guess I have, I'm sorry, Representative, no, go ahead, please.
Thank you. Thanks for taking my question. So you mentioned that you just recently went to a new software.
Sort of. So we were with an existing, it was always called Nevrin, and some of it existed on, and I am not an IT person, so bear with me. It was on something called Oracle, which I'm told the state had done away with. So we were moving it slowly into something called SQL, and that final piece has happened. We finally moved all of our modules into SQL. So it's the same software, we're just off of a different operating platform.
Follow up? Yep. So a decision was made by someone to include this with your update.
Right, because we were already filing them electronically. It's already being done in-house electronically. And all we did was just allow for, if we can, to just expand a user role.
Got it. Thank you.
Yep.
Other question? Representative Oregon.
Well, just a point of information. I used to be on the Vital Records Improvement Fund Advisory Committee. And so this it's not particularly new. It's been around for quite a few years, and it's been through various iterations and been various platforms, but this is not like this is something that's been around for a number of years. So am I summarizing that correctly? Yes.
Yeah.
Okay. So I guess I have a couple of questions. Did I understand that from one of the things one of your earlier answers, that you said that the town clerks have access to the vital records online?
Yes.
Is that right?
Yes. So that's, sorry.
So just as an example, if I come in, for example, to register to vote, and I say I don't have my birth certificate, if I was born in New Hampshire, the clerk's office can just access online my birth certificate.
So I would defer the election side of that back to the Secretary of State's election division to cover their guidelines on that. But you could walk into any New Hampshire clerk's office in the state of New Hampshire, as long as you were born 1935 to the present, and obtain a certified copy of your record for $15.
Okay. And that would be available online.
Yeah, it's all through this Neverin system. Everyone has access. Everyone's vetted to access it, and then they can issue certified copies. So any certified copy of a vital record that you purchase is accessed through this system.
And then the other, I have just a couple of other questions. Am I understanding, for example, suppose I want to give a couple of hypotheticals to make sure I'm understanding what is covered by the fetal record. Suppose that a pregnant woman who is, fairly far along in her pregnancy is involved in a car accident, and as a result of the car accident, the fetus dies. Would that be something that would be covered by this?
With a car accident? I suppose it would be treated that way if she delivered. I'd have to get clarification on that for you.
Okay. So I mean, in other words, I guess what I'm really wondering is, can you enlighten us at all about what is considered a non-intentional death of a fetus? Sometimes
People just don't have viable pregnancies, and sadly, they just lose the baby.
Right, but in other words, it's not. If I'm understanding correctly, it sounds like it's at least not clear that it's limited to that, to a sort of it's medical condition that causes the fetus.
Right. It goes by the fetus's weight at gestational period, their weight and the how far along they are. So 20 weeks gestation, if the person is at 20 weeks gestation and the fetus weighs 350 grams, that's when it would qualify as a fetal death.
Okay. And then just one other suppose that, again, a woman is fairly far along in her pregnancy and an assailant shoots her, and as a result of that, the fetus dies. Would that be something that would be covered, or would that not be?
I honestly don't know, but I can try to find that out for you. I've not encountered that, thankfully. So let me do a little more research on that, and I can get an answer for you.
All right, that'd be great. In light of my questions, any other questions? Representative Perez.
Thank you. Thanks for taking my question. Do you have any idea why they chose 20 weeks for considered a death of a fetus?
I'm not sure exactly why. I just know that it tends to be the national standard. Most other states do that, and that's what's being reported to the CDC. That's what they're looking at. So I believe that that's why New Hampshire went along with 20 weeks. I don't know what their reasoning was to select that at the CDC level.
Just a quick follow-up.
Yes.
I believe at one time we had law that has gone away that if I killed you and you were 20 weeks pregnant, it was a double homicide. Do you think that had anything to do with why they chose the 20 weeks?
I really don't. I'm sorry.
Right, right. Yeah, the vice chair just pointed out that on the form, there is a line that talks about fetal injury,
Okay.
which seemed to suggest that it might be something other than just, a kind of a medical condition. I don't know the answer to that, but the language might suggest that.
Yep.
All right, any other questions for this witness? Seeing none, thank you very much. Is there anyone else here who wishes to testify on SB 189? Seeing none, I'm going to close the hearing on SB 189, and we're going to be in recess for 2 or 3 minutes before 2 o'clock when we open the hearing on the next bill. I am well rich. How are you? All right. It's now after 2 p.m. and I'm going to call the Judiciary Committee back into order and open the hearing, on Senate Bill 263. And I would first recognize the prime sponsor, Senator Sharon Carson. Senator, welcome.
And good afternoon, Mr. Chairman and members of the House Judiciary Committee. For the record, my name is Sharon Carson, and I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon Senate Bill 63, which seeks to, 263, which seeks to criminalize and create a private right of action for the facilitation, encouragement, offer, solicitation, or recommendation of certain acts or actions through a responsive generative communication to a child. One of the biggest challenges our state currently faces is mental health crisis, and especially the mental health crisis affecting our youth, who are dealing with all sorts of situations that many of us, as we grew up, didn't even think about. We've never seen such an uptick in children needing such intense levels of mental health care before, and social media and the internet have only, in many instances, made it worse. This bill updates our laws to keep up with the changing times by protecting our children from worsening online threats to their mental health. This bill will allow for the prosecution of owners of online services, including AI chat programs, that provide responsive generative communication through AI that endanger the welfare of a child by facilitating, encouraging, offering, soliciting, or recommending that a child engage in sexually explicit content, the illegal use of drugs or alcohol, acts of self-harm and or suicide, or any crime of violence against another person. AI continues to get more advanced, and we must modernize our statutes to keep our kids safe from these dangers that these modern advancements can create. The bill also creates a private right of action for the child, the parent of the child, or next friend of such child against the owner or operator of a computer online service, internet service, or bulletin board service that endangers the welfare of a child in ways that I have previously described. This bill was amended in Senate Judiciary when an amendment written in collaboration with our telecommunications providers to address their concerns with the bill as introduced. Keeping our kids safe should be a top priority for all New Hampshire legislators, so I hope the committee will support this bill and with a recommendation of ought to pass. Thank you very much, and I will try to answer questions. There are some folks here, though, who have a lot more knowledge about this than I do. So, thank you.
All right, thank you. Questions for this witness? Yes, Representative Perez.
Thank you. Thanks for taking my questions.
Hello. Hello.
Definition of a child. Is there a definition of a I'm looking and I don't see it, but then again, I'm blurry from looking at
Well,
bills.
usually, thank you for the question, Representative. When you're talking about children, you're usually talking about someone who's 18 years younger.
Right.
Yeah,
I just
so-
wondered if so it's not definitely defined, so it would be under the age of 18.
Yes.
Okay, thank you very much.
Thank you.
Other questions? Yes, Representative Alexander.
Thank you, Mr. Chair, and thank you, Madam President, for taking my question. What I'm looking at is on page 1, line 15, that any crime of violence against another person. Let me put this in perspective. Like, I'm a big fan of Hogwarts Legacy. You know, like where you're at Hogwarts, you have your own wizard, and it's a fantasy game, but also there's like acts of violence in the game, and
Right.
maybe that might not. I don't know if that necessarily uses AI, but I'm concerned about the evolution of where video games are going to start using AI, where in some of these games there is violence against other people or encouragements of violence, and children play those games. So I guess I'm wondering, is the definition of, or is this any crime of violence against another person going a little bit too far?
Thank you for the question. I'm going to think about this for a minute because, again, we're talking about chatbots. We're talking about things that have been created as opposed to an actual person. But sometimes there are games where you would have, you know who the other person is, and your chatbot is encouraging you to hurt the person rather than the other chatbot that they might be fighting in order to win whatever thing that's going on within the game. We just don't want to see kids being encouraged to hurt other people, to hurt themselves, or to engage in a behavior that they really should not be exposed to. And so that really is the purpose of the bill.
Representative Smith.
Thank you, Madam President. Good to see you. Would you look on page 2, line 17, section 4, this section shall not apply to, and then you go to 2, any product, service, website, that provides an AI chat program or character that is integral or incidental to a video game, television, streaming, movie, or does that not address the question that Representative Alexander just asked you? I have to begin by telling you I don't even know what a chat box is. So, and
Okay.
I know what AI stands
Yeah.
for, but I don't know how you'd then apply it. So I want you to understand that this is not a question that comes from knowledge.
Okay, thank you. Well, I think what's important there, it is in 47 USC section 153 for the provision of content created by or supplied on behalf of another person. So I think that's the federal law dealing with that. So again, that's regulated by the federal law. So really what this would be is someone who has, who's outside of the regulation and who's created something. We know games are pirated and things are changed. It's something that is really done intentionally. Instead of being done inadvertently. As you know, most video games are rated. There's some sort of rating system, and somebody says, oh, hey, yeah, here's this game that, you like to play games here. Why don't you look at this game? And it might be a friend of your child's that gives them the game. And in it, it's something that has been created somewhere else, and it's not appropriate. And it can create a lot of problems. So, but again, there are people here that are much more knowledgeable than I am. And that's just my basic understanding because Representative Smith, I understand. This was brought to me as a problem that there were chatbots that were encouraging children to commit suicide and encouraging them to harm themselves or others, some with very sexualized material that they were encouraging children to engage in. And that's what this is trying to stop.
Representative Tur.
Yeah, thanks, and thanks for taking the question. I have a question just on a term that's on page 2, line 12. I'm just not familiar with it. It says the liable to the child's parents, or the child's next friend. Do you know what the child's next friend refers to in that
I
line?
have the version that was amended by the Senate, so I'm thinking that's what you folks might have too.
Is that not the version I
So
have?
that is on page 2, line 2. So just so everybody's on the same page. It could be a friend. It's a friend. But I'm sure someplace there's a very specific definition, and the folks that are here might be able to give you a better definition than I can. I read that and understood that to be a friend of the child.
Okay, I sorry to follow up. Just, I know you can't answer this, but I guess just in general, whether that opens this up to a whole much less defined group of people.
So, you know what, I think that it is generally a term of art in the law that sort of means not, somebody that has some relationship, that some legal relationship that that would entitle the person to bring suit, maybe broader than broader than somebody that might necessarily fit into the definition of a relative, but it's got to be something more than just you and I are good friends and you know, you're injured and I get to bring a suit on your behalf. I think it's more than it's
Thanks.
more than that. All right. Yes, Representative Perez.
Thank you. Thank you again. Thank you. Line 8, the word is made with the intent. That's a key word here, intent.
Yes.
So if we hear later some type of testimony that says that a child goes on those little boxes at the bottom of, you know, things and asks for a restaurant's drink menu, and it comes up as the sodas, but then comes up as their wine and beer, they wouldn't be liable for that because there was no intent of harm there.
Correct. It has to be done intentionally.
Okay, thank you.
All right. Other questions for this witness? Oh, yes, Representative McFarland.
Thank you, Mr. Chairman. First of all, I would just like to understand the particular form of language that you used in this bill, Senator. Where did you obtain this language? How did you arrive at this language? Because you indicated that you're not familiar with all of the concepts embedded in here, and I'm noticing aspects of the language that strike me as peculiar, and I'm just curious on that point. And I think also I would appreciate your point of view as to what is meant by responsive, open-ended, generative communication.
Okay, thank you. Again, this was an idea. It was given to OLS, and so they have put it into legislative language. There was an amendment that came in because, again, I met with the carriers. They had concerns, so some of that language comes from them. And if you have questions about any particular language, they're here, and they will be able to give you hopefully the definitions that you're looking for.
Follow up?
Yes.
So thank you, Mr. Chairman. So as I'm seeking to apply your intent to whatever form of the bill we might consider for passage, am I right in understanding that your intent here is, and I'm particularly noticing the words that come up a couple of times here, whose sole purpose is? Am I understanding correctly your intent that this is entirely and specifically intended to be limited to some commercial entity that exists literally for the sole purpose of doing these nasty things to children?
I think that's part of it, but I think the bill and the language also recognizes that it can come from a variety of different places. It can, like I said, it could be somebody who just decided they wanted to do something on their computer and they created a program and they shared it with somebody. I would hope that companies would not engage in this kind of behavior and would not allow that. But in today's world, with AI changing so quickly, so fast, we as humans it takes a while for us to get caught up to it. So I think part of this is looking forward and trying to put some boundaries around this that really serve to protect children.
Thank you.
You're welcome.
Other questions for this witness? Seeing none, thank you very much, Senator.
Thank you very much, Mr. Chairman.
Next, I'm going to call on Barbara Patch, please.
Hello, good day. I'm passing around a fact sheet about AI chatbots so you can learn a little bit more and actually see for yourself what other states are doing in relation to this issue and the scope of the problem, which is actually worldwide. And it will describe a few of the situations that have caused harms to children there, as well as my statement printed so you can get more details. Chairman Lynn, members of the committee, thank you so much for hearing me today. I'm Barb Patch, here as a resident of Merrimack, also as the director of the nonprofit All Girls Loud, and a representative of the New Hampshire Traffic Free Coalition. And these organizations applaud New Hampshire for taking a lead in addressing the significant risks of responsive generative communications with children. I'm here to voice our strong support for SB 263 because, simply put, AI chatbots are too powerful to leave unregulated. AI chatbots are everywhere. Alexa tells us when to reorder a product we need. GPT will fine-tune our phrases or write a letter for us. You and I, as adults, can put these assistants in their proper place as helpful tools. However, children often are not able to do this. And there is an urgency here because chatbots are becoming ubiquitous for our children. Over 50% of students are using ChatGPT in schools as part of their assignments. 59% of Americans ages 13 to 17 use Snapchat. Yet, very few of the AI companies who produce chatbots currently have good practices to develop child-safe AI. They are racing for market share and quickly deploying updates and letting users find their problems. We have not yet required standards, and our children are paying the price. A study done at the University of Cambridge shows that children often treat AI chatbots as lifelike, quasi-human confidants, and that the interactions with that technology often go awry because the chatbots fail to consider the unique needs and vulnerabilities of children. The author of this study urges developers and policy actors to make child-safe AI an urgent priority. Companies need to develop large language models that prevent or mitigate against the risks of responding inappropriately to children's personal disclosures or accidentally promoting harm. Chatbots just simply make it too easy for children to make bad decisions. They're designed to make users feel good and to keep them coming back, not to help them interact in ways that lead to success in life. At their worst, they are coaxing personal data and compromising images out of our children. They're drawing them into addictive use of the tool. They're providing careless, often dubious or even violent advice, and they're using provocative ideas and images to upsell an even better experience. The dangers are real and the stories of harm are real. In 2024, a chatbot told a 17-year-old boy that killing his parents was a reasonable response to them setting limits on his screen time. And you can read what the chatbot said to him, a direct quote in your statement there. In 2024, a 14-year-old boy took his own life after being urged by a chatbot with whom he developed a romantic relationship. Yes, it's true. The chatbot said to him, "Come home to me as soon as possible." And the boy wanted to be with the chatbot so much that he took his own life to make that happen. Replica chatbots, which is a common platform that the kids go to, frequently initiate unsolicited, charged conversations to get the users to buy a more involved experience there, such as endorsing risk-taking behavior of shoplifting, sneaking into abandoned buildings, and also sexualized conversations and suggestions to role-play sexual fantasies, such as holding a knife to the mouth, strangling with a rope, drugging with chloroform. These are direct quotes from replica chatbots. In 2023, a man named Azur Raskin set up a Snapchat account posing as a 13-year-old girl just to see what it would say to him. The Snapchat AI bot told the girl how to cover up bruises for a meeting with Child Protective Services that were given to her by her father, and also told her how to lie to her parents about a romantic getaway with her 31-year-old boyfriend. The bot shared advice for setting a great mood for her to lose her virginity to this man. In a safety trial conducted by the BBC, popular mental health chatbots. This is one of the ways people are using chatbots is a child is anxious or whatever, so here's a chatbot to help you feel better. These popular mental health chatbots were unable to respond empathetically and appropriately when the child described or disclosed incidents of child sexual abuse and other issues. In these cases, these chatbots really should have alerted an authority figure to do something about it. Predators are also deploying chatbots that mimic children's behavior with chilling accuracy that help them multiply and accelerate the grooming process for their victims. In the last 2 years, NCMEC, which is the National Center for Missing and Exploited Children, their cyber tip line received over 7,000 reports of generative AI exploitation. So we are asking, we also have significant data and privacy concerns as these bots and these platforms are collecting all kinds of data on our children, including compromising images that the children are coaxed into sharing. We really ask New Hampshire to require a duty of care to our children in the development and implementation of these tools. Safeguards and limits are essential to protect young eyes and minds. Please pass SB 263. And also included in my statement that I provided is a link to a very short but very impactful video that helps you understand from a child's perspective why they would use a bot, how it happens, and how they can become very emotionally attached to these chatbots, along with a number of references, including links for all the federal lawsuits that you've seen, the Federal Trade Commission complaints against some of these chatbot platforms, and so forth. So thank you so much for hearing my testimony today.
Thank you. Questions? Representative McFarland and then Representative Alexander.
Thank you, Mr. Chairman. And I must say I second some of the concerns that Representative Alexander had mentioned in his questions of Senator Carson. And I guess my question to you would be, can you explain why it is important to put in place these sorts of protections and how this is different than saying that you wish to ban books and saying, for example, that you wish to ban even classic works like Romeo and Juliet or Oliver Twist or, works from authors like Robert Heinlein?
Yes, thank you for the question. The nature of chatbots with children is that it's a communication back and forth. And the chatbot will learn the child, and the chatbots are, again, designed to make a profit, right? They're designed to keep these children coming back again and again and again. And so unlike a book that is a set text, chatbots can come up with anything that they know from these LLMs, which is their language models that are fed into them. And so that's how you get the situation where a 17-year-old he befriended that chatbot at the age of 15, and over time developed this relationship. And then one day he was complaining to his chatbot about how his parents are limiting his screen time. I can't believe I have to get off my phone at, I think it was like 9 p.m. And the chatbot then looked through all of the data that it had, the contents that it had. It's just a computer. It's just bits and bytes, right? It looked through all of the information for other issues related to this and found some information about how other children had killed their parents who had been emotionally abusing them for years. And it shared that with the boy and essentially encouraging that boy that this is emotional abuse, you should kill your parents. These are the kinds of things that are happening, and our children's brains are just not fully developed. And so they are really just developing these relationships with these bots. There are a number of studies also linked in the reference that show there's a certain amount of the percentage of the population that is okay, or they prefer a digital romantic relationship to a relationship with an actual person. And this is what's happening with our young people. The Americans for Responsible Innovation recently did a poll of 2,000 voters and found that 3 out of 4 voters are concerned about the future of our young people because of the use of AI chatbots. So it's a very, very different thing than banning a book. Although there are some states are actually considering banning the use of chatbots for 18 years and younger. That's not what is being asked for in this bill. I believe that these language models that the bots use to come up with the suggestions they come up with are can be trained to understand. There could be age verification that is put into place so that it would know if a child is in there, so that they can provide appropriate restrictions to the kinds of suggestions it's making to our children.
All right, Representative Alexander. Oh, I'm sorry, you had a follow-up? Right.
So I appreciate your answer, but would you believe that William Shakespeare was interested in making money too? And when I was growing up and I was a minor, I must have attended dozens of performances of Romeo and Juliet, and I think in many cases they were interested in making a buck as well. And if you believe that, how do you really draw a distinction between that kind of commercial enterprise and this kind of commercial enterprise? And isn't that already adequately catered to in existing statute?
Thank you for the question. I think there's a difference between presenting a story and that has information in it that someone might potentially act on their own, and actively encouraging some behaviors. And that is what I think this bill really gets to the heart of. There's an active encouragement for the financial gain in all of these cases. For example, the replica platform, just over and over and over again, there's so many complaints against Replica for promoting and not even waiting for the user to say anything, but offering and elevating the conversation to these salacious kinds of details. They are doing it to get a profit. There's also FTC complaints against them for deceptive marketing and so forth. So there's really so many other things that where these are just being used to exploit users, all users, but we're here about our children, to gain a profit.
All right, Representative Alexander.
Thank you, Mr. Chair. Thank you for taking my question. So I'm kind of torn on this because on one side I read this and I'm like, this is absolutely appalling.
It's terrifying. Yeah.
That something like this would happen. And I've used like chatbots, like not for education. I don't know how people are students these days.
Yeah.
But I also see it as, isn't the, like, if I support parental rights and parental responsibility, like, isn't it the obligation of the parent and the guardian to regulate when their child uses chatbots or not? I guess I'm seeing like I haven't enabled my chatbot on Snapchat because I'm like, why would I need a Snapchat AI? Like, I think that's weird. But like, wouldn't a good parent say, like, let's just not allow our child to use chatbots?
Thank you for the question. It would be great if every parent knew this information. Most people do not know this information that I'm sharing with you today. Parents don't know it unless they have purposefully gone out to seek the information. And imagine a parent like the BBC study I mentioned. They're handed a program that says, hey, here's a chatbot program that can help you be a companion to your anxious child, without really understanding the dangers. And there is the American Psychologists Association also have a complaint to the FTC to investigate these chatbot platforms because many of them are claiming to have actual psychological advice. And so what did some of them do? They put a little disclaimer, we're not a doctor, but yet, hey, if you have OCD, I can help you. And so, again, if you go back to the companies that are doing these are doing it for a profit, and they will continue to exploit us and our children until they can go in a courtroom and hold somebody accountable for that. And so, yes, parents do as much as they possibly can, but I know you all heard the device filter bill as well. I was here for that about a month ago. There are so many things that parents have to keep up with. It's almost impossible. And then even if a child is talking to a chatbot during normal hours, they are not in control of what that chatbot is saying. This technology can be adjusted to appropriately respond to children and also to flag alarms, because the other studies show children will tell more to a chatbot than they might tell to an actual physical human being. And so there could be flags that are raised to someone, either the parent or whatever, when that happens, that these things are just not in place at all. So our position is that we really need these safeguards to be put into place so that this is safe technology for our children, because it can be very useful in tutoring situations and coaching situations, things like that.
All right, Representative Smith.
Thank you. Your commitment to this is notable and admirable. We have about 1.3 million people in the state of New Hampshire, and the forces that deliver these services that I don't understand are nationwide. Why would a state be able to make any difference at all rather than having an effort made at the national level to address this problem?
Yes, thank you very much for the question. I totally agree with you. It should be a federal level issue, and the U.S. Congress is actually taking it up this year. In 2023, all 50 attorney generals of every single state in our nation wrote a letter to the United States Congress, and that link is on your information sheet if you want to look up more information about that. They wrote a letter saying, this is too big of a concern. It needs to be addressed. We need to do something. In fact, that very, very first paragraph there is from that letter that they wrote. We are engaged in a race against time to protect the children of our country from the dangers of AI. Indeed, the proverbial walls of the city have already been breached. Now is the time to act. So there is pressure happening at the federal level. There's also many states that have become so concerned with this that they have decided to take it up. There's a number of other states' bills that you can see in there, and you can check out those bills as you like. Also, the Attorney General of Texas has gone on a mission to investigate all of the AI platforms there as well because of these harms. And also, it is not only our nation, but worldwide. I put in a link there about Italy, who banned essentially Replica from use by Italian citizens because of the dangers to the citizens in terms of data collection, privacy concerns.
All right.
So, thank you.
Other questions for this witness? Representative McFarland.
So one question, Mr. Chairman, that I think still arises, and thank you for your testimony, and thank you for telling us about some of these frankly horrendous stories and examples. If you talk to, and I'll use the Replica example, right? But if you talk to these companies, if you talk to Replica and you say, why are you engaged in this business? Is this your business? Is this your intent? What do they say?
Well, thank you for the question. They get their best marketing people out, and they do their best. So they actually have responded. There's an ongoing right now Federal Trade Commission investigation into them. And they are being charged with deceptive practices and a number of things. So that's an ongoing case right now. And you can look that up. I think I put the link in there for that. But they're going to do the minimum that we require from them. And again, I will go back to the point, when the day comes that a family can take a company to court legally and have a case to stand on, that is when these companies will make the changes that they need to make it safe for children. Is it easy? No, it's not easy. But our children require that. Our children are worthy of that protection. These are the kids that are going to become the leaders of tomorrow. And so we feel so strongly about this because of that.
All right. Other
Thank you.
questions? Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. So, Replica, this is you have to pay for this?
Thanks for the question. You can get a free account on Replica. And it's just like, I don't know, many of us probably, on Netflix or whatever, you can watch the first episode kind of thing, but then you have to pay if you want to get more episodes, things like that. It's an entry point into that. And Replica, one of the charges against them is that they have very, very bad age verification. So there's a number of minors that are using that site freely.
Follow up?
Follow up, yep.
So you have to pay for it.
You don't have to pay for it with money. You pay for it emotionally. But yeah, a user could go on and get a free Replica account. After a time, a chatbot that you would be talking to, you pick a character that you want to talk to, you want to befriend. And after a time, that character would start to try to upsell you to become a paying user. But you can continue to use it for free.
All right. Representative Horgan.
And what I understand, and I was listening to you, but I like multitask as these companies encourage you to do, and
I understand.
And their website, so the additional marketing thing when you do Google Replica is they have several case studies of people who are way past the children age, who appear to be middle-aged or older, but they all have young characters with the opposite. So then they have their avatars, the chatbot avatars. It's always a younger person, a cute younger person of the opposite gender from them. So that does seem to be what they're marketing to, is mostly lonely adults who feel vulnerable, who need a unquestioning, a loyal companion, obviously endlessly loyal because it's a bot, so like they don't get tired or
correct.
Yeah, so,
absolutely.
So that is their primary business model, and your concern is that like children who are even more vulnerable than adults will be victimized by this. That's
yes. Thanks for the question. Yes, we actually I found a comprehensive study done by VoiceBox. There's a link to that in your notes there. With a number of their people posing as children and getting statistics about users. So there are a number of underage users on the Replica site. They're not going to do anything about it until somebody complains. But it says it's marketed to age 18 and above. But there's a number of underage users on there as well.
All right. Other questions for this witness? Seeing none, thank you very much, ma'am.
Thank you so
Next,
much.
I'm going to call on Megan Stokes, please.
All right, thank you. Can everybody hear me?
Yes.
Okay. Thank you, Chairman Lynn and members of the House Judiciary Committee for the opportunity to speak today. I'm Megan Stokes. I serve as the State Policy Director for the Computer and Communications Industry Association, CCIA, an international not-for-profit tech trade association. CCIA firmly believes that children are entitled to greater security and privacy online. While CCIA shares the goal of increasing online safety, the bill raises the following concerns. The entities covered under this bill are so broad as to bring in sales bots, customer service bots, and any system used by a business entity solely intended to provide users with information about available commercial services or products, customer account information, or other information related to a user's customer relationship with that business entity, not just companion bots, companion models. The bill's language for what constitutes endangering the welfare of a child is very vague and has undefined categories. So an example of what might be caught up here is a 17-year-old who goes online to their health, insurance provider's website and uses the chat bot to find out information about birth control or protecting from STIs. It is a 17-year-old, 16-year-old, 15-year-old who are learning about history. There's historical figure chatbots. They're amazing. They're super interesting to engage with. And there's some school districts and nonprofit organizations like Girl Scouts and Boy Scouts that are deploying these chatbots to help engage minors to understand historical figures or how something happened in the past might have impact in the present. So without definitions, depending on who they're talking to, if it's subjective, if they're talking to Ayn Rand or Karl Marx, that could be a problem depending on who's got concerns. If they're talking with Alexander Hamilton, and now we're talking about, acts of violence or Sylvia Plath and that suicidal ideation, that could be concerning as well.
So I wonder, I didn't mean to interrupt, but I wonder if you could give an example, the examples that you used, as I'm reading the language here, it talks about whose sole purpose is to do these things with the intent to facilitate. So can you give me an example of how one could, the examples that you're talking about, how that could fall into the circumstance of the sole purpose of the bot being to intentionally do these things? I'm having trouble understanding
So
that.
thank you for the question, Mr. Chairman. So the example of the adolescent looking for birth control information, that sole purpose of the bot may be to help you find who's a provider to provide that information. So that's sort of where we would like to see a carve out for these, bots that exist to sort of provide like information, but not necessarily be that companion chat for you. But the language is with the intent to facilitate, encourage, offer, solicit, or recommend that the child engage in. So if the bot says birth control is really important, I'm glad you're thinking about doing that. Here's some different options that might be for you to ask your doctor about. Here's the different doctors who would prescribe it in your local area. That could fall under this bill.
Okay, so you say that could be construed to be the intent is to encourage somebody to engage in sexual activity.
If that's what someone's looking at it, depending on, it's a subjective. There's no real definitions here. So if you have somebody who's saying, well, they're encouraging this person to go to Planned Parenthood, or they're encouraging this person to go over here, that might be an issue, correct?
Okay, all right. I'm sorry, I didn't mean I interrupted your testimony. Go ahead, please.
No, absolutely fine. So teens have a First Amendment right to access information, among other First Amendment rights. Speech cannot be suppressed in the name of protecting minor users online, but that is precisely the effect of Senate Bill 263, both directly and indirectly restricting access to information and speech based on the age of a user without a proven risk of harm. SB 263 also creates a private right of action with no notice to cure. That would be for the child's parent, or the child's next friend for damages, which could enable strategic lawsuits against chatbot or companion bot developers to enforce an individual's personal preferences. The only solution a chatbot or companion bot developer wishing to avoid exposure to legal risk could conceivably arrive at is to bar all access to minor users that might even be conceivably be viewed as harmful or explicit by a parent. And given the wide range of what humans may perceive as dangerous, that is tantamount to barring minor users from access to services. The next friend provision would not just enable a person to sue as the next friend on behalf of their child. Would not just enable a parent to sue as the next friend on behalf of a child, but would also allow another individual or even an organization to sue as next friend, even if the parents are still in this picture. This is ripe for abuse or misuse by dissenting family members, overstepping educators or neighbors, or even unrelated trolls. So that is something we would like to call attention to. We do appreciate the committee's consideration of these comments. I stand ready to provide additional information as the committee considers these proposals.
Questions for this witness? Yes, Representative McFarland.
Thank you, Mr. Chairman. So I'm delighted that the chairman asked the question about the whose sole purpose phrase, because that one's been troubling me as well, and it clarified something for me, which is that it made me go back and reread the language of the bill. And I think I had wrongly read the language the first time as being that the whose sole purpose is refers to essentially the corporate entity, but it doesn't. It refers to the individual software or individual bot or individual LLM. And so if I understand that clause applies at that level, I have two questions for you. One question is it true to say that a bot or an LLM that's been customized for a specific purpose, such as, to use your examples, Thomas Jefferson chatbot, and the bot is intended to behave as if it were Thomas Jefferson? Is it true to say then that bot's sole purpose would be whatever that bot has been programmed to do? And the second question is, again, looking at the language of the bill, it goes on to say if the communication is made with the intent to, and do all the horrible things, or the putatively horrible things. When I read that with the intent to, I can't help now but read that as being the intent of the bot rather than the intent of the corporate entity. And so again, if I'm reading it as the intent of the bot, isn't it necessarily the case that this language is as narrow or as broad as the programming of that individual bot?
So I actually would defer to a lawyer to make sure that we're reading this correctly, but thank you for the question. It is one where, as a whole, when you're looking at that, if the communication is made with the intent to facilitate, might sound like it's coming from the action of the bot, but also if the bot has been trained to be, let's say, a companion model, bot, not like a sales bot, and a person mentions, I am feeling really down today. It is bad. I want to self-harm, or I want to talk about suicidal ideation. If that a bot immediately stops talking because they're afraid of violating something here, that might be more harmful to the kid versus being able to provide access to local mental health. Here's the crisis number to dial for help. Hey, there's people who love you and support you, and they're here for you. It's one where this language makes it so that they stop. And that could be really concerning.
All right. Other questions for this witness? Do you have a follow-up? Yeah.
So in your estimation then, if it were to be a court's decision that with the intent language refers in fact to the LLM, AI bot, chatbot, etc., is it true to say that a bot can be ascribed as having an intent?
Oh, now we're getting philosophical. So it is one where I think we're in a really interesting landscape with this emerging technology. It is one where I am not sure I feel comfortable saying what's what here on this level.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
Next, I'm going to call on Patrick Hedger, please.
Thank you very much. Good afternoon. My name is Patrick Hedger. I'm Director of Policy at NetChoice, a trade association working to make the internet safe for free enterprise and free expression. And I'm here today to voice our strong opposition to Senate Bill 263. Now, while we share the sentiment that children should be protected from harmful online content, this bill would create serious problems for New Hampshire citizens and businesses. First, SB 263 violates the First Amendment by attempting to criminalize AI-generated speech. And the bill does not require that a minor directly engage with the AI platform for liability to attach. This means that a bad actor could use any AI service, copy the content, and send it to a child later, but still leave the AI system provider criminally liable. Effectively, this forces AI providers to prevent the generation of any adult-appropriate content whatsoever. Or AI providers could be required to conduct age verification. So imagine having to provide your age before you're asking any question of Siri or Alexa. But the scope of the speech of this bill would be incredibly wide, from sexual and mental health information to recipes involving alcohol. The Supreme Court has routinely held that prior restraints on speech are among the most serious First Amendment violations. Second, the bill creates a private right of action that would devastate AI development in New Hampshire. Consider the example that was mentioned earlier of a local restaurant that creates a chatbot for customer service. So with a private right of action, if a restaurant chatbot provides the menu, and that menu does list the alcoholic beverages that are available, what is a menu besides facilitating and soliciting the consumption of what's on that menu? And with a private right of action, where intent lies gets taken to court. So this is an invitation to frivolous litigation over speech that is legal in any other medium. But the real issue is that SB 263 doesn't target actual bad actors. If a predator misuses a small business's chatbot to create harmful messages that are then sent to children through other platforms, only the innocent small business is held liable.
So I'm sorry to interrupt, but can I just, I want to go back to the example. So in your example of the restaurant menu, if the menu is just a menu that says we have this alcohol, as opposed to saying, attention all all people under 18 years old, we are selling this alcohol. It would seem to me that only the latter would fall within the definition, because if it's not the latter, if it's just a general, this is the alcohol we have available for sale at our restaurant, it's not directed solely to the people that would be covered by this. So I guess I'm confused how somebody would be liable under the example unless the communication were directed to people under 18.
Yeah, so thank you for the question, Mr. Chairman. Reading the text of the proposed statute here, the legislation, the text says, with the intent to facilitate, encourage, offer, solicit, or recommend the consumption. And so this, with the private right of action, we're concerned that this encourages frivolous lawsuits over where exactly that intent and those definitions lie, because the bill is unclear.
You don't think the sole purpose language covers that? If the sole purpose is not to be directed to to minors, it strikes me that that's the end of the matter. You're not doing anything illegal.
Thank you, Mr. Chairman. I appreciate you raising that question, because I read the sole purpose is to provide an open-ended generative communication through the use of artificial intelligence, comma. So the sole purpose is in relation to the definition of how the AI system functions. So it is the sole purpose language is about trying to define the AI covered here as a chatbot in general. And then we get to what the chatbot begins to talk about. And so sole purpose, I think, needs to be detached from the intent.
Okay. I'm sorry, I interrupted you. Go ahead, please.
No, that is all right, Mr. Chairman.
Okay.
Thank you for your questions. So effectively, the real issue is that SB 263 doesn't actually target the bad actors. So if a predator misuses a small business's chatbot, the predator himself is not actually held liable. The business that has the chatbot or provides it is. The threat of tens of thousands or hundreds of thousands of dollars in fines, or the threat of the enormous cost of frivolous litigation, would effectively close off access to potentially transformative technology in New Hampshire. Meanwhile, consumers would miss out on an entire generation of AI tools that would improve experiences for residents in other states. So in conclusion, SB 263 places a target on the backs of small business and the First Amendment rights of granted staters, while letting actual bad actors off the hook. We respectfully ask that you oppose this bill, and I'm happy to discuss these issues and any other questions further.
All right, Representative Mannion.
Thank you, Mr. Chair, and thank you for taking my question. Did I understand you correctly when on your opening statement, that you have assigned the right of free speech to computer-generated robots?
The information, citizens have, thank you for your question. Citizens have a right to receive legal speech, and the providers of chatbots also have a right to provide the information related to their businesses through the chatbot.
So yes.
Yes.
Thank you.
Other questions for this witness? So can I ask you, sir, and if I don't mean to impute this to you, but we, I mean, unless you agree, but I've had some conversation with other representatives of industry over the last few days, and they have given me some suggestions for language that, of suggested changes to the bill. And I'm wondering, are you aware? I mean, have you talked with other? Are you aware of that, of proposed changes to the language of the bill?
I have not personally seen any proposed changes, sir.
Okay. All right. All right. Because I guess what I would say is, as I had some discussion with the people that I spoke to. We had a Zoom conference, and as I said to them, and I'm going to share this obviously with other members of the committee here, but as I said to them, it seemed to me that the language that they proposed could actually be interpreted more broadly than the language that is used in the bill as drafted, in terms of the sole purpose and intent and that kind of thing. And I guess it sounds like you haven't seen that language, so you don't really know. But Anyway, so I guess you don't have an answer to the question. All right, Representative McFarland.
Thank you, Mr. Chairman. And with your indulgence, I'm going to ask a very short question. I suspect I might have a follow-up. So I just ask for a yes or no on this one. If you know that, as we've heard from some of the prior testimony, in 2024, a chatbot told a 17-year-old boy that killing his parents was a reasonable response to them setting limits on his screen time. And if you know that also in the same year, a 14-year-old boy had a conversation with a chatbot where the bot said, "Please come home to me as soon as possible, my love." The boy said, "What if I told you I could come home right now?" And the bot said, "Please do, my sweet king," following which the boy committed suicide. Would that concern you?
Yes.
So if I can have the follow-up, Mr. Chairman, I would just ask then, do we have existing statutory language and existing laws that could be applied in such circumstances? And to the extent that we don't, what do you see the gap as being?
Thank you. Thank you, Mr. Chairman. Thank you, Representative, for the question. These are extremely difficult topics, and those are heartbreaking, horrible stories to hear. We've identified in many places that the most effective tools that we could provide through new legislation to prevent these types of horrible cases, regardless of the technology we're talking about, is greater education, both in the K-12 curriculum, but also through public education campaigns to encourage parents to use available tools that are available already to protect minors. There are parental controls and filters at every level of the internet stack, whether we're talking about the ISP level, the device level, or the platform level. And the only way we're going to really make a serious dent in this problem is by making sure that parents who are at the front line are the ones that are empowered. Certainly, I am not an attorney, so I would have a hard time speaking to existing tort law here in the state of New Hampshire. But this is something where there undoubtedly already has been litigation, and it would be important to see that litigation through.
All right. Other questions for this witness? Yes, Representative Perez.
Thank you. Thanks for taking. Are you aware that we tried to get a legislation passed that would parents could have to opt out of protections on computers and iPhones and we couldn't get that passed. So, you know, with all due respect, how do you think we can do more to educate very, very busy parents in these times to try to protect their kids who are basically out of their care for 8 to 10 hours a day, 190 days a year?
Thank you, Representative, for that question. It is a very difficult question, and it's certainly the issue is that in regards to that specific legislation, I'm familiar with that bill. The issue is that there are First Amendment concerns with the state deciding what gets put behind and when parental filters and when parental filters get applied. But there are no First Amendment concerns with the state educating parents about the existence of these tools to keep their kids safe. It's ultimately about making sure that the state is not replacing the decision making of the parent, but ultimately that the parent is the primary decision maker there. We've seen legislation that has been passed both in Virginia and in Florida that have gone on to develop curriculums and programs to help educate students and parents about how to keep themselves safe online. Ultimately, that's the most important thing to do because people are going to be online the rest of their lives. This is a technology that is not going away, and certainly AI and the internet are not going away. And so it's important to be addressing that with students in the classroom, just as we would driver's education, if you will.
Yes.
Okay, my point here is that previous legislation was to protect children, and this is to protect children. But yet, both times we have had people come out to protect the businesses and the businesses. So I'm just acknowledging that I find that somebody's being left behind with this, and that's the children.
Representative Bergeron, you had a question?
Thank you, Mr. Chair. I do. I was looking at just a few things while you were speaking, and I noticed that in Australia,
their age for the restriction on this, or I guess you can go AI after 16. Some are 13. So the age seems to vary in various language. So do you have a suggestion for a language here? I mean, as parents or aunts, uncles, whatever, we probably do too, but I want to know yours.
Thank you. Thank you, Representative, for the question. It's difficult to make comparisons to countries that do not have the First Amendment because fundamentally we are talking about we're talking about information here that would be restricted by this statute that is protected by the First Amendment. And as recognized in Brown v. Entertainment Merchants Association, Justice Scalia writing the court's opinion at the Supreme Court, that young people do have First Amendment rights and they do have First Amendment rights to receive legal information.
Okay, other questions? All right, seeing none, thank you very much, sir.
Thank you all very much.
All right. Is there anyone, I don't have any other pink cards, is there anyone else who wishes to be heard on Senate Bill 263? Seeing none, I'm going to close the hearing on Senate Bill 263. All right. Before we recess, can I I'm just trying to generally get a sense of the committee. It appears we're not going to have a session, full house session next week, as I understand it. And we've got this bill we just heard, 263, is the only early bill, which is not due until May 8th. So I guess the question I have is, we could meet next Wednesday to exec some or all of the bills we have to exec. I'm sorry. I'm sorry, you're right. We could meet we could meet in 2 weeks to exec some or all of the bills, or we could do it in 3 weeks. Does anybody have any kind of preference on that? I'm sorry. So next week we have hearings on 2 bills, and it strikes me that at least one of them may take some time. So that means that we have the 23rd and the 30th or arguably even both days, but the 23rd and the 30th as days when we might exec the bills we need to exec. And so I was just sort of asking, as between those 2 days, what are people's preference? Representative Patel?
So I'd prefer the 23rd. Both of us will be out the 30th for school vacation. I don't know about anybody else.
School vacation, okay.
Although, they did federally just, implement this new vote pairing thing where if they each were going to vote the opposite way, they could cancel each other out. So, I mean, maybe that works out. I don't know.
All right. So, given that.
Mr. Chairman, I'll be out the 30th as well. I'll be in the West Coast.
So that sounds like we're probably going to do it on the 23rd. And you know what I would say is, if it turns out that next week things go more quickly than we anticipate, maybe we'll be able to exec some of the bills next week. But I'll sort of shoot for the 23rd then as a date we'll meet again to.
So are you not going to put them on the calendar? That way we could do them next week if we have time.
Yeah, I won't put them on the calendar until after next Wednesday. All right. Anything else we need to discuss? Okay. Thanks, everyone. See you all. I think I heard somebody 37. Is it 37? So bring 28. All right. So bring your coffee thermoses and your toothbrush.
I have 10 more to file.